filed an affidavit in connection with Dusty service yesterday. The same may be brought on record.
Wait, please, Your Lordship. With respect to item number 26, Lordship, the engaging counsel, his father has been hospitalized, so I'm seeking an adjournment.
26.
26, Your Lordship. Admission hearing. Both are tagged matters, Your Lordship.
Okay.
Obliged.
What do you want?
Any date, I'll take the date from the court.
Is that your good name?
C. Gogo, Your Lordship.
The Google. Learn it counsel for the appellate.
Yes, Your Lordship.
With counsel for the other side, let's call listing the matter after. After the.
Obliged, Your Lordship.
Fair. Yeah.
May it please your lordship, I beg to mention a matter PL 627/2024 for listing for admission.
Or
Admission.
court number 8.
Your,
Court number 8.
your lordship,
You mentioned it before court number 8.
court number 8.
Senior court.
Lordship, I beg to mention an RSA matter that was listed on 2019, last date, and thereafter it was never listed again.
Court number 8.
May it please your lordship, I beg to mention 3 IAs for listing.
Court number 8.
List.
May please, Honor, as per the direction of the court, I have filed the additional affidavit.
Why?
Additional affidavit from the, on behalf of the accused number 1 and 2. I have annexed the charge sheet, earlier disposing order.
Okay.
That's part of the record, my lord. The next
Yes. But we have to call for the record
Yes, ma'am.
from the where it is standing.
No,
Dhupuri, my lord.
Dhupuri.
CJM code Dhupuri, my lord.
Or
Special judge, Dhupuri.
for the accused and the for the to learn a additional issue for the respondent. Is application addressing or activity of the plaintiff is deferred by the accused. Deferred by 2 accused named Mohammad Haidar Ali and Haidar and Mohammad Rasidul Ali alias also Ali, who are the accused jailers connected with the PS case number 313 of 2024 under section 22C 29 and the PSI 6/49/2024. The learned counsel for the accused submits that it is the second bail application.
Second bail application.
Second bail application. And the first one was dismissed by this court by order dated by order dated by order dated 28/1/2025 year number 3886 of 2024. Then what stage it is pending now? Charge the frame.
Charge of frame. Maybe it is in evidence.
Evidences. The learned counsel for the accused further submits that the case is pending for the court of where it is pending
Special judge Dhupuri.
for the court of learned special judge Dhuri at the stage of evidence. The stage of evidence. They are taking note of the submission of learned counsel to the petition for the accused and also the learned that provided that necessary for the scan copy of the record along with the report of learned special judge Dhuri fixing the matter of itself judge Dhuri with cricket activities. Or
Hello. Hello.
May I please, Lordship? Both the matter is interconnected. Two is filed for by agreeing the order, stay order of trial court, where the execution proceeding of the state. The trial court has stayed. The respondent has to produce the stay order passed by the Honorable High Court, but they could not. They have filed. They have produced only order passed in delay condone petition.
The
So-
RSA, the delay is yet to be controlled.
Yet to be condoned. And
So
I
you
have
have
to file
received-
objection.
You have received notice.
No notice has
IA.
been, in the IA, no formal notice has been yet received by the respondent. But I have get knowledge from the court. So I have to file objection.
You want to file objection.
Objection.
When?
They, further they have to instructed to furnish copy. They have not
You have
furnished any.
No, Lordship, we have not furnished them a copy. Lordship. I'll be furnishing a copy today, Your Lordship.
Today.
pardon.
This week, after 2 days, 3 days.
Today,
Hmm.
I you will take out. Third minister, your good name,
Yes, Gautam, Your Lordship.
learned counsel for the applicant, and it's B. Upak, learned for the opposite party, just struck. 1 and 2.
Ah.
1 and 2. So Upak submits that though he has not been furnished, not received any copy, but he had the information about tendency of this regular second appeal. And he will file objection in his application file under section 5 of the Limitation Act. And press for drafting for 3 days time. And also, Mr. Upak submits that the applicant may be directed furnish a copy of the application. If possible, it reports that the learned counsel to the applicant submits that during the course of the day, he will furnish a copy of the application to Mr. Upak. Accordingly, it is provided that the SSL is submitted on Wednesday,
Wednesday,
6th of August.
stick the pocket. Lordship, I have filed color, but name has not been shown in first list.
Okay.
Maybe.
Some further submits that he has already filed local number. Interlocutory application. But the same is not, but his name is not reflected in the first list. Accordingly, it is provided that the SSL do the needful.
Deeply obliged. Obliged, Your Lordship.
May please, Your Lordship. In this case, Lordship, against a transfer order, I have filed this revision petition, Lordship. My plaint, Your Lordship, will find in page 11, annexure 1.
No, that's all right. On the other day, you apprise this court that you will.
Yes, Lordship.
you will
Is there any
submit some
authority,
case
Lordship?
law.
Yes, Lordship.
So that you will suffer prejudice.
Yes, Lordship. One judgment I have found where it discussed this, if there is a pecuniary jurisdiction, Lordship, that objection has to be raised, Lordship, at the earliest. While discussing the Supreme Court judgment, Subhas Mahadev Vasa Habib, Lordship. Or Snehaleta, Lordship. Lordship will find in court page, Lordship, court page paragraph 23. I have downloaded it from the online, so there is no page number and all this, Lordship. Court page paragraph 23 in Harshad Chimanlal Modi, Lordship.
But the problem is that both the suit relates to the same plot of land.
No, Lordship, for that only I want to show your Lordship that annexure 1, page 11. This is the suit filed by the petitioner in the year 2022 on the basis of a registered sale deed, Lordship. He purchased from the respondent's predecessor, Lordship. It clearly mentioned in page 14 and 15, Lordship. Lordship, kindly see page 15, paragraph 2. of my revision petition. The suit lengths are also different.
So that number, patta number. is
Same
the-
tag number, patta number, but lordship, that patta contains 16 bigha of land. And my earlier suit is only for 3 bigha I have purchased from the predecessor of the respondents, lordship. That clearly I have mentioned in paragraph 2, page 15, that Abdul Gofur, son of Gulab Ali, owned and possessed 3 bighas out of 16 bighas, 1 katha 5 lusa, covered by dag number 211, periodic patta number 122, situated at Kupati Mari under Moja, Buragaon. So my case only in respect to these 3 bighas through a registered sale deed. And their case is for partition among the legal heirs of their Gofur's lordship, Abdul Gofur. So in partition, I have
Not
nothing to.
only partition, there is also pair for right title and interest.
Yes, lordship. But that is their suit between the legal heirs of Abdul Gofur, lordship. Annexure 3, page 24. They are all the legal heirs of Abdul Gofur, except this defendant number 1.
On the other day, you have submitted that you will furnish case law to show that you will be prejudiced by the aforementioned order, by the impugned order. Where is that
Lordship,
discussion?
the one suit is pending before the Civil Judge Junior Division and one suit is pending before the Civil Judge Senior Division, Lordship. Now the Junior Division suit, after decree, appeal will be filed before Senior Division, Lordship. Now the petitioner will lose one forum, Lordship, for his appellate authority, if both the suits are decided by Senior Division, Lordship. That is one aspect, and one aspect is that, lordship, the my suit land is a purchased land, and their land are, lordship, to be distributed among the legal heirs of Abdul Gofur. So in that case, when they did not file, they could not file written statement in my suit, lordship. After giving ample opportunity, they failed to file written statement. Then they filed this second suit, lordship, impleading me as defendant number 1. Lordship, kindly see the prayer portion of the second suit, page 34. A decree be passed declaring that the plaintiff shall have right, title, interest over the A schedule land of the plain, and a preliminary decree be directing the principal defendants to effect partition of the plaintiff's share by metes and bounds and for delivery of the possession. Same to the plaintiff within the date to be fixed by the court be passed. If the principal defendants fails to partition and deliver, I am a purchaser, lordship. How can I partition their paternal property, lordship, and deliver possession of the plaintiff's share of land within the date fixed by the court? Then the court may be pleased to deliver the possession of the plaintiffs by appointing court commissioner. A precept be issued to the revenue authority to effect revenue partition with respect to the land out of A schedule property that come to the hand of the plaintiffs by the aforesaid decree of civil partition and after the delivery of the possession by the court. And their scheduled land is only 8 bighas. Page 36, a plot of land measuring.
So the problem is that the suit land of the present petitioner's title suit.
That is in respect to 8 bighas and I am claiming 3
Same.
bighas. My suit is at the stage of judgment,
That
lordship.
aspect was taken note of by the current district judge while passing the report.
Yes, lordship. But their prayer portion, your lordship will see, page 43, 5, paragraph 5.
I
They
have already seen it.
yes, lordship, they have stated that on the same date, lordship.
Will say heard Miss Artsonary learned counsel for the petitioner. Order is that
Obliged.
Your Lordship. In this case, I'm appearing for respond number 1, Lordship. Matter cannot be settled, Lordship. The policy dispute is there.
policy that's the
Yes, sir.
heard. Who is the appellant? You.
My lord, I'm the applicant. Please.
I am for one insurance company, Lord.
Or Mr.
K. Vishwakarma, my lord, appearing on behalf of Mr. S.P. Chaudhary.
Learned Counsel appearing on behalf of Mr.
S.P. Chaudhary.
S.T. Chaudhary, Learned Counsel for the appellant and Chaudhary for respondent number,
One, Lord.
respondent number one. Chaudhary submits that the dispute. There is dispute regarding the policy. And there is no sort of the matter being compromised among the parties and thus speak that the matter may be listed for hearing.
Order, Lordship, because LCR hasn't come. Order.
LJ,
LCR, half LCR has come, Lordship. Matter may come up for order, Lordship.
right for listing the matter for order as the LJ has not yet been received.
Half LCR has been received, Lordship. LCR is not complete, Lordship. Incomplete record.
Whether respondent number two entered appearance,
Service,
No, my lord.
service resumed.
have you taken any step?
No, Lordship. Okay. Respondent number two is the claimant, Lordship.
This is the claimant.
Respondent number two is the claimant. They are the owner, Lordship. Appellant is the owner of the vehicle. And claimant is respondent number two.
Necessary to hear that party.
Yes, Lordship.
Yes, lordship, because the issue is with regard to the payment.
Dated 31/5/2025 indicates that no step has been taken by the counsel for the appellant about the respondent number two. Accordingly, it is provided that the learned counsel for the appellant shall take precedent upon respondent number two by registered post with ADL also by the process with the name with. And this is also issue reminder to the learned professional for keep the entire record. The further delay, list the matter after. This is the 2012.
2012, Lordship. 2012.
Matter for
Lordship.
Obliged.
Must oblige, Lordship.
May it please your lordship. Your lordship, this case is not fit for mediation, your lordship. This case is not fit for mediation, your lordship. This is not on quantum.
not fit for mediation.
Yes, your lordship, not fit.
But in fact, Lordship, this appeal is not maintainable because the award is only 58,000. So this is less than 1 lakh as per section 173(2). Lordship, the appeal, no appeal shall die against the quantum of Lordship less than 1 lakh. So in our High Court has also has.
Lordship, there are other
I-
analogous cases arising out of the same accident. So lordship, my prayer is that another date may, a short date may be fixed for hearing this matter on this point, your lordship. My senior's presence is required for disposing of this case.
Let Mr.
Short date,
Krishnan has
Lordship,
also
next
requested
Wednesday.
me to take up this matter in any other day, Lordship.
Ordinance be brought across, learned counsel for the then for the offline. If something better, something in the car. Then it is not that just for referring to the mediation. Referring to the mediation, that is not the matter of mediation. On the point of maintainability.
Yes.
Of the. The maintainability of the appeal in view of the provision of section 2 to section 173 of the MPA.
Next week proceed any date. Only short order is required.
On
Can it be on 6th, your lordship? 19th.
Yes.
Oblige your lordship.
My lordship, 7 is same, here lordship 64,000, what is there lordship?
It's not fit for referral to the consideration. You can challenge our liability of it.
If the appeal itself is not maintainable, why should I refer to the petition?
Not it, this limitation, this slab of 1 lakh that came in the year 2022, but where there is no policy or where policy terms are violated, in that case, that may not be applicable. And in this case, accident is of 2017.
No,
Accident is of 2017. And
April
amendment
file is the
date
year
is
2022, and this provisional lordship has came into effect from 1/9/2019. 1/9/2019. April file is the year 2022.
Well, I heard the matter on the point of maintainability.
But
But
our,
Mr. Ages Sakya learned to the appellant. Mr. Khan learned on this submitted at the bar. Mr. Khan learned counsel submits that the appeal itself is not maintainable in the provision of section 173 certificate to hearing. Accordingly, it's provided that there's a matter for hearing on the point of maintainability. It's not
but at same date lordship, the same issue is there. 19. 19. Item number 6 is given 90.
Items 8 and 9.
Please, your lordship. In this case, my lord, the issue involved is, my lord, that my lord, claimant was entitled to the amount is been decided, my lord, but only, my lord, is a pay and recovery case, my lord. So security has been granted, my lord, for the owner, my lord, to pay first, and thereafter the amount will be released, my lord. On that, my lord, we have came before your lordship. And so, my lord, I think, my lord, is a point, my lordship has to decide, my lord, nothing to the mediation, my lord. And regarding, my lord, service, my lord, what I'm pointing out, my lord, on last occasions, my lord, justice service has been granted to us, my lord. We have taken the steps, we have submitted our affidavit, my lord. In that, sir, regarding justice service upon the respondents, my lord, 2A and 2B, my lord. We have filed an affidavit, my lord. 2A, 2B, my lord. After death of that, respondent number 2, my lord, his legal heirs were substituted, my lord, and thereafter justice service we have been granted to serve to justice service, my lord. So we have taken the steps, my lord, and we have filed an affidavit also in that regard for service of someone upon respondent number 2A and 2B, my lord.
Yes, madam, you are appearing for?
Respondent number 1, your lordship, the insurance company.
Mr. Sakya?
I am for 1 in item number 9. You are in 8, no?
Yeah, you know.
Item number 9.
I am 9. This in.
I am
8.
respondent number 1 in item number 8, your lordship.
I am the learned counsel for the appeal. And they are for the respondent. Number 1.
1.
Mr. Alam submits that no purpose will be served by referring the matter for mediation. And the dispute raised appeal has to be decided by this court. And accordingly, provided that this can take the matter for hearing.
Yes,
Service completed.
Yes, ma'am, service complete, madam.
Hearing service upon that number 1 and 2.
2A,
have
2B.
already been completed. View of the office note dated 25/6/2025. Please record it.
Much obliged.
Oblige, madam.
I am on behalf of respondent number 3, your lordship. Respondent number 3, your lordship. In
In
both
both the case, my lord, respondent number
both
2,
the
madam.
case.
8 and 9, madam.
Your good name, please.
Yes, okay.
Yes.
See.
Oblige, madam.
Not same issues involved in this, 21,000 only.
Not only 21,000, in this particular case, they were traveling in a auto rickshaw where person permissible limit is 1+2 and 1+3. They are traveling 11 person in the auto rickshaw. So policy did not cover. We have adduced defense evidence regarding the policy condition, and the policy has been exhibited that we have no coverage for the 1 plus 10, 11 passenger was traveling in auto rickshaw. Coverage is 1 plus 3. 1 is driver and 3 passenger, but they are traveling 11 passengers.
No, the maintainability of this appeal is being questioned.
Maintainability not question. Maintainability is regarding quantum. We have said if quantum is challenged, then maintainability will come. If quantum is not under challenge, then maintainability will not come. Because if amount in dispute is less than 1 lakh, we cannot prefer appeal. Amount in dispute. What is amount in dispute? If there is no amount in dispute, there is dispute regarding policy condition. Otherwise, insurance company is not going to prefer appeal because 21,000 is nothing. They have to pay the fees to the advocate for preparing appeal. Only because they have no liability.
But is it provided in the section 173?
Lordship.
Section 2?
That is provided amount in, if amount in dispute is 1 lakh. What is this?
No, where this proposition is settled?
In the motor vehicle act itself. Section 172. No appeal shall be against any award of a claims tribunal if the amount in dispute in the appeal is less than rupees 1 lakh rupees. This is not amount in dispute. 173(2). Thank you. Otherwise, we should not prefer an appeal. We have preferred appeal only on the ground that policy is not covered.
No, that's all right. But is it provided in the section?
Lordship, it is provided. 173(2).
No, that's all right. It is provided there. But whether your submission is covered by this section?
No appeal shall be lied, Lordship, against any award of a claims tribunal if the amount in dispute, that is the criteria, amount in dispute. Here we have not disputed the amount.
No, that's all right. But the awarded amount is here only 21,000.
21,000.
In 121,000, one is 51,000.
So 11,
Okay, sir.
item number 11.
I think not even.
You show me the provision that when the quantum is not challenged, then it is mentioned.
I will let Lordship fix the next week. We will produce the judgment. Good.
Heard Mr. Goswami learned for the place the matter on. Okay. 8 over.
10, 11 same, Lordship. Both of us, 10, 11 same. Obliged.
For hearing on the point of maintainability of the appeal.
Obliged.
Lordship, this matter pertains to condemnation of the Lordship. Lordship, we have no objection in this matter, Lordship.
But the applicant is absent. Appeals for the applicant not how about sir? Your name?
A. Lotha, Lordship. Correspondent number 1.
Please come enter after 1 week. After 1 week.
Obliged, Lordship.
May I pray, madam? This after appeal is admitted, when this matter has already been compromised outside the court. So therefore, we have filed this compromise petition IS Civil 2317 of 25. Whereby we have agreed, the insurance company has agreed to pay an amount of rupees 20 lakh.
Yes, Lordship. The claimants are agreed, Lordship.
So there's a settlement disposal.
Yes.
Smile.
Heard Mr. A. Bhattacharya, learned counsel for the applicant. Then move to heard Mr.
A. Borua.
Learned counsel for the opposite party.
1 to 4.
1 to 4, Lordship, for claimants.
This right compromise application is quite on behalf of the applicant. From appellant, and the respondent number 1 to 4. The MSC appeal number of the file. Yes, sir. But as the learned and counsel for the applicant submits that the matter has been settled between the parties and the insurance company, the appellant, in MSC appeal number 246 of 25. And agreed to pay a sum of rupees 20 lakh as full and final payment to the respondent number 1 to 4.
Yes, sir.
So borrower learned for the respondent submits that matter has already been settled between the parties and as such is appeal is disposed on the strength of compromise. Taking note of the submission of learned from the parties that filed the application. Stands allowed. MSC appeal number 246 of the 25 stands disposed of on the strength of compromise and in terms of whether any deed is prepared.
This is the compromise petition.
Deed prepared was
No, but this is the compromise petition signed by both the parties. Here I have given the affidavit of both parties, man. Page 8 and 9.
On the terms and conditions, without in the application, in the central. Terms of this,
My lord, statutory default may be refunded.
This 25,000 shall be returned to the appellant.
Lordship.
And the 20 lakh we will deposit before the registry of this honorable.
And thereafter, the claimants may be allowed to withdraw the same after proper verification.
You have deposited the amount
We will deposit after this order, my lord.
within 1 week.
Within 6 weeks, my lord.
No, not. Mr. Bhatta said the learned account to the submitted to deposit the entire amount before the registry of this part. That is the borrower learned account to the respondent number 1 submits that the party, the respondent may be party to the efforts of from the registry of this part. Here is according to
Obliged.
Lordship has recorded
another IA was filed.
that was for stay earlier.
In view of the order passed in I number 3. Is the application number 183 of 2025.
Obliged. Here also, my lord, same, my lord, amount is 32 lakh.
Here, the respondent.
1 to
1
4.
to 4. Same.
I'm appearing for response number 5.
Fine.
The owner.
Owner of the vehicle.
Your name, please.
H. Mozumdar.
H.
H. Mozumdar.
The matter has been settled.
Matter has been settled between the insurance company and the claimant. So they have filed a joint settlement.
Here the amount is
32 lakhs.
32 lakh. And MSC appeal number 231 of 25.
Much
Much
obliged.
46.
On a page for the color of this the matter of 1 week.
47.
May I please, Your Worship? Lordship, this matter may be referred to mediation.
But the other party is absent.
Absence, there is an IA for continuation of 80 days, but we have taken a step, but they have not filed their Okalat now.
So whether notice was
Sir, as per office note, notice has been not served.
heard is that
SI Akan.
SI account learned function for the applicant. The central to the application. It's preferred by the applicant for conduction of pay of petition. Office note dated 31/7/2025. It's that their ID card or after it's to respondent return. also to the court respondent related. You want to take press essay?
Lordship,
The learned counsel for the applicant submits that will take press essay upon the sole response. Or the case is provided is the petition by registered post with ADN of the vehicle. It is somewhere 4 weeks.
So obliged.
48.
made please your lordship.
But I have ascertained the amount was deposited.
Deposited, Lord.
Deposited. The only thing is that he is asking for release of the amount, my lord. As per direction of the Honorable Tribunal, my lord. The tribunal, my lord, directed, my lord, that 50% of the amount, my lord, directed 3 lakhs, payment of 7,50,000, which you have challenged, my lord. Now, out of that, my lord, 3,50,000 was to be, my lord, kept in the fixed deposit of the girl, minor child, my lord. It was a minor child who met with an accident, and my lord, the compensation granted was 7,55,000, out of which, my lord, the tribunal directed that 3,50,000 be kept in the fixed deposit of the girl. So, my lord, now we have deposited, my lord, 3,75,000. If the entire amount is released, my lord, then this order will get to a certain extent modified, my lord, because the rest of the amount was supposed to be kept, my lord, for the welfare of the child, my lord, because here the ground that has been taken for release of the money is the husband of the petitioner, my lord, claimant had died, my lord, and therefore, my lord, they are in, my lord, hardship. That's why, my lord, this, but this was actually payment, my lord, with regard to the accident met with the, my lord, minor child, my lord.
In para number 6, lordship.
% of the awarded amount is rupees.
3,75,000,
Yes.
which you have deposited.
Then what was the direction of the tribunal?
Tribunal's direction was payment for 7,50,000 total award. Out of the 3,50,000 was to be deposited in the account of the child, fixed deposit, of the child.
So whether with the remaining amount that can be satisfied.
But then our case is that as per Supreme Court's judgment, 5 lakhs ought to have been the maximum compensation. So 7,50,000 she will not be eligible as per our claim, appeal. That's the ground we have taken. That Supreme Court has said in case of such a child,
That will
5.
be taken care of at the end of final hearing.
That will not, I mean, just it was my duty to point out to your lordship, as your lordship pleases, my lord.
That is, it says let the amount be withdrawn by them.
My lord, subject to my lord, certain, my lord, undertaking that, my lord, if in case, my lord, because we are also, my lord, of course, that is a different issue. We are also asking for pay and recovery. That's another issue, my lord. But then, so first 5 lakhs is concerned, my lord, we say the as per Supreme Court judgment is 5 lakhs to be paid, not 7,50,000.
Hard is that?
SRN Nasir.
And also hard for this one. This interlocutor application is prepared by the applicant for releasing 50% of the awarded amount deposited before the estate court by the appellant. For both the parties, provided that the amount deposited before the registry of its court shall be released in favor of the applicant. Terms of is IS and disposal. Then in MSC appeal, main method.
MSC appeal, my lord, I think, the respondents, my lord, the owner of the vehicle has not appeared, my lord. So perhaps we could take first step again. I just saw him, did not check out, my lord. Okay, question, no? If no one has been appearing in this case.
You are for respondent number,
I'm put a claimant for me about 1 minute. One.
respondent number one. And who is for respondent, who is respondent number two?
Respondent number 2, my lord, is the owner, my lord, of the vehicle, my lord, or that's two well, my lord. They are, my lord, the
Notice upon respondent number three has been charged
my lord.
to return and serve.
My lord, 2 is the, my lord, owner of the vehicle, my lord. 3 is the driver.
Driver.
Whether he has contested the case.
My lord, in the my lord, case, my lord, no, my lord, there was no contest as such. My lord, they filed written statement, my lord. They filed written statement, but then did not reduce any evidence, my lord. Page 30, lordship will find, my lord, OP number 2, owner and driver of the vehicle. They filed written statement, my lord.
Now tell me whether his presence is necessary in this particular.
Because, my lord, we are asking for, my lord, pay and recovery, that will be necessary, my lord. Because we say there is, the driver didn't have the vehicle license, my lord.
You are for the
I have the appellant.
but
Yes, I'll take place first on the respond number 2, my lord.
part is the sorry.
Yes, sorry.
Part one.
1, lordship.
So they did 23rd, 2024 tickets that part 2 later transfer order. With the report and they office not also that service report in respect of respondent number received by the legend. But none adheres to the respondent number three. Well, so not to learn about the evidence of instead to take test of part two. Accordingly, it's provided that the book taken by Mr. AEN of Squid of also for it.
Develop.
Lordship, kindly pass over the matter for time being. My senior is on lake, Lord.
Item 16.
May I please, your lordship? Order dated 21st July 2025. Directed to me file a additional affidavit for bring on record of the sale certificate of respondent. Page number 1010, lordship. Already filed additional affidavit. lordship. 109 Annexa B series, lordship. Sale of the respondent April, May and June 25.
109.
9. 11% 110, 1111, 112. Sale certificate of the respondent.
So what was the direction of the trial court?
Therefore, direction was the 8,000 per month as per Hindu Magic 24 lordship. It is directed to the petitioner to pay monthly interim maintenance and 30,000 for pending of litigation cost lordship. Challenge this order by this petitioner lordship. Because respondent is a government service holder, same rank lordship.
But they were to maintain the children.
Lordship.
And for children, how much you were paid now?
12,000 for my children, 2 children lordship.
12,000.
12,000. I have
That
not
has not
disputed
been
this.
challenged by you.
No, no. Only challenge the section 24 lordship. Here, bro, lordship.
Here, Bora, learned for the petition. None appears for the respondent. The Bora, learned concept for the petitioner. of its that or to order of this court dated 5 by the Appellate Executive Court, the statutory certificate responsible. Argument from concluded order is that all order.
Mass of legislation.
17. Adjournment.
এটা দাও লিস্ট সঙ্গে
ঠিক আছে
My lord, this matter is pertaining to the Mangalore
Yes, yes.
learned Munshi Justice passed an order, my lord, on.
Sir, the law
Yes, my lord.
state of disposing of this interlocutory application cannot hear the petition.
Yes, my lord. In fact, my lord, last occasion, that was the understanding that the entire petition will be heard and disposed of. Because practically, my lord, if the interim order is to be revisited, my lord, then there will be no point keeping the CRP pending by vacating the interim order.
That is here on the main petition.
Yes, yes.
Who will argue first?
If, my lord, it was his petition.
He's the petitioner.
Yes.
I am the petitioner in CRP, my lord.
Okay. You argue first. But let us go through the impugn order.
My lord.
Let us go through the impugn order.
Yes, my lord. My lord, impugned order lordship will find that annexure 7, page 120.
Order dated 15/5/2025.
Yes, my lord. Order dated 15/5/2025. May I read it, my lord? The present case traces it. My lord, before I start, may I just highlight the facts of the case, my lord? Lordship, may kindly turn to annexure A1, my lord.
Sir, B1.
A1 at page 16.
Yeah.
My lord, this is the
Title, sir.
title suit before the Munsif Judge, learned Munsif Judge. Well, Robinde is the plaintiff, and there were originally 6 defendants. And my lord, from defendant number 7 to 17 are the pro forma defendants in the suit. Altogether 17 defendants originally. Then defendant number 1 expired. Defendant number 2 also expired. In place of, my lord, in place of defendant number 2, defendant number 2A and 2B are inserted as legal heirs, and the present petition is filed by defendant number 2A, Mrs. Lovita Das, and 2B is her minor daughter. You know, there is a correction, handwritten correction towards the left of the file.
Yeah.
My lord, this defendant number 1 and 2, Minu Das and Kaushik Das, both are expired now. They are the legal heirs of one late Torani Das. In fact, the father-in-law
late Toranidas, he inherited this property from their ancestor, and that is how we are now in charge of the suit property, my lord. Defendant number 3, 4, 5, and 6 are also the inheritance of one Chittaranjan Das. My lord, this Chittaranjan Das and Torani Das, they were our ancestors. They got this property from their ancestor, my lord. Why I am pointing out to this, my lord, in so many pages there are the word defendants are occurring, my lord. Though this petition has been filed by one particular defendant 2A, she also represents 2B, because the suit parts that they are claiming, we decide there, my lord. So others probably they are, my lord, they are not disturbed by that impugned order. Now defendant numbers, pro forma defendant 7 to 17, they are the legal heirs of one Manoranjan Day. My lord, why they are incorporated? Because, my lord, Lordship remembers, I have pointed out on last occasion, that is also in my petition, that there was a title suit in 1998 in respect of the same property filed by Manoranjan Day against our ancestor, that is Tarani Das and Chittaranjan Das. That was decreed in our favor. Right title, interest, and possession has been decreed in our favor. That decree of the learned Munsif Judge was challenged in an appeal, and appeal also got in our favor. That was in 2000, I think, my lord, 2008, that 2012 that decree was passed. I have handed over that bunch of documents. I can again hand it over, my lord. That was probably, I'll hand it over one bunch, my lord, because this has a connection, my lord. Lordship, the very first page, Lordship, the plaintiffs are Tarini Das and Chittaranjan Das, as I have mentioned in the plaint. And the defendants were, my lord, on death of Manoranjan Day, these are the defendants. Who were the pro forma defendants here? Lordship, I'll kindly take your lordship to page number 9 of that bunch. That is the operative part of this judgment earlier. That is title suit number 38 of 98, renumbered as 2F 2007.
Yeah.
I will write that order. The plaintiffs have succeeded to prove their case. The suit stands decreed on contest with cost against defendant number 1 and ex parte against the rest. The plaintiff's right title interest in respect of Schedule A and B lands is hereby declared. The possession of her Schedule B land is hereby confirmed. The defendants are hereby restrained from dispossessing the plaintiffs from their Schedule B land issued receipt to the Circle Officer, Mangaldoi Revenue Circle, to delete the names of so and so from the land record with respect to the Schedule A land, prepare decree accordingly. Means we were the plaintiffs and it was decreed in our favor. Lordship, thereafter the decree is there. Kindly turn, my lord, next 3 pages. The handwritten schedule of the decree is there. Schedule A land measuring 1 katha 5 lesas covered by Doug number, that is N, 1 katha 5 lesas covered by Doug number 573. Well, this will be 572, probably in Xerox that has gone, my lord. A total land of 2 katha 10 lesas under the periodic patta 402 of Mangaldoi town. This Doug number 572 and 573 of patta number 402 is the subject matter of the present suit also. That is Schedule A, and Schedule B, there is another Doug. Yes, Schedule B, land measuring 1 katha 5 lesas covered by Doug number 572 under periodic patta so and so, so and so, so and so. Now, my lord, under 572 of periodic patta 420, the present plaintiff is claiming the suit part. It's on 572. My lord, this was challenged in an appeal, title appeal number 6 of 2008. Next page is the certified copy of the appeal order. Lordship may kindly turn to the operative portion at last page. And before that, my lord, the date of the decree in the appeal may be noted 10th of August 2012. And it was given at the last page, my lord, order. From the findings on foregoing issues, I find that the appeal is devoid of merit, and as such, the appeal is dismissed on contest with cost. The impugned judgment and decree passed by the Munsif number 2 is hereby availed. Send down so and so, so and so. In these two appeal and suit, my lord, our ancestors were the parties, both Tarini Das and Chittaranjan Das. Now, in the present case, we have inherited from them, my lord. That is why, my lord, I wanted to point it out this. Now, lordship may kindly turn to the prayer in the plaint. It page number, my lord, it will be at page 722 of this CRP. This suit was filed in the year 2013, and prayer was for a decree declaring that the plaintiff has an easement right on the suit part described in Schedule B below the plaint. For a decree declaring that the right title interest of the defendant in the suit part, if any, has become barred by adverse possession, and further decree declaring that the plaintiff is the owner of the suit land on account of adverse possession and law against so and so, decree of permanent injunction, restraining the defendants, their servant, employees, or any person at his behest from doing any act or obstruction of the suit part in any manner, and from raising construction, any house and structures and obstruction, so and so, so and so. Next page is the schedule of the land. Schedule B is the suit part, that is the suit land, a part measuring 10 feet in breadth, 80 feet in length, as shown in the rough sketchment, out of an 1 kata 5 lesas of land covered by periodic patta number 402 of Dag number 572, situated at so and so, my lord. My lord, why I am pointing this, my lord? When our right title and interest has been confirmed in a decree on October 2012, thereafter, my lord, immediately thereafter in the year 2013, the plaintiff has claimed the right of adverse possession against us, my lord. Our right has accrued in the 2012 by virtue of this decree. And therefore, my lord, this prayer in the plaint, the decree declaring on the basis of the adverse possession, is per se not maintainable, my lord. However, this point has been raised in the suit while filing the statements by the defendants. But, my lord, that is not been taken up as a preliminary issue because the suit is still in the stage of, my lord, because of so many defendants are there, my lord, SR and WS has not yet been completed. Still, the matter is, to my instruction, it is in the stage of SR and WS. In that suit, my lord, there was an injunction filed, injunction petition. Injunction petition was ordered on 26th of March 2015, whereby my learned trial magistrate said, maintain status quo in respect of the suit part. Though we in our written statement said, an objection also we said, there is no suit part as along because the land is a composite land, it has been covered from all the sides, and there is no part, and he has, as we have won the case, he might have some setting with the plaintiff earlier. As we have won the suit, and we took possession of the property as per the decree, he filed this case and claimed that road through our patta land. That was, injunction order was granted on 26th of March 2015. We filed an appeal. Appeal was, in that appeal, there was an interim order, stayed the injunction order. That appeal order came on 16/5/2016. Against that order, my lord, they have preferred a revision before this Honorable High Court. High Court, my lord, on 17/6/2016, my lord, re-imposes the status quo. And that status quo is continuing till now, my lord. Now, the Honorable Guwahati High Court, while in the earlier set of civil revision, my lord, directed us to maintain status quo, and there are some directions, my lord. I will take your lordship directly to that, my lord. That therefrom the issue has cropped up, my lord. Lordship, that order your lordship will get At page 89, my lord. Annexure 2.
Yes.
This is a common order. Lordship finds CRP IO 379 of 19 as well as CRP 199 of 16. What happened when this 199 of 16 was filed by them? Then there was also a violation petition filed and direction was given to demolish the structures on the suit part. We have challenged that and both the petitions were taken up together. Lordship, while this petition was taken up, Lordship may kindly turn to page number. I'll just read the relevant portion, my lord. Lordship may kindly turn to page number 97.
Yes.
No, before that, I'm sorry, my lord, 94 may be taken up. I'll read one paragraph there also. Paragraph 8 at page 94. Para 8. The record further reveals that in the said proceeding, various applications thereupon were filed from time to time alleging that the defendants had put barricade and concrete wall on the suit part and to restore the suit part as on date of passing the status quo order. The learned trial court fight order dated 1/10/2019, taking into account that from the materials on record, it appeared that the defendants have violated the status quo order in respect of the suit part by making construction over the suit part and thus preventing the plaintiff and his family members for ingress and egress through the suit part, passed a direction for restoring the suit part to the original position as it stood as on date of the status quo order. Accordingly, consequential directions were passed, thereby directing a superintendent of police Dorong to execute the order in presence of adequate number of police personnel, circle officer, Mongoldo Revenue Circle, in order to prevent the deterioration of any kind of law and order. My lord, against this 1/10/2019, we filed the second CRPIO. My lord, both are taken together. Why I am reading this paragraph? Because it says there was an allegations that on the top, my lord, it says alleging that defendants had put barricade and concrete wall on the suit part. My lord, the allegation is that that particular suit part was blocked by raising barricade and boundary wall. Thereafter, Lordship will kindly turn to page number 97. My lord, what happened at paragraph 15, I will read. Moving forward, may I, my lord? Moving forward, it is also seen that during pendency of the suit as submitted by so and so learned counsel appearing for the respondents, this respondent is the present petitioner here, my lord, that during the period of passing of the first appellate court's order and before passing of the status quo order by this court on 17/6/2016, my lord, I will pause for a moment here, my lord. My lord, here says before passing the first appellate court's order. That is, my lord, order dated 16/5/2016, when the first appellate court stayed the injunction order, as I have already said, my lord. Am I clear, my lord? It says before, sorry, my lord. It says during the period after passing of the first appellate court's order and before passing of the status quo order by this honorable court on 17/6/2016, the defendants have made certain construction by raising a tin sali house. On the other hand, Mr. So-and-so Learned Senior Counsel for the plaintiff submitted that the defendants raised construction by constructing a wall as well as blocking the ingress and egress, for which proceeding under Order 39 Rule 2A was initiated before the learned trial court. He further referred to various applications which were filed before the learned trial court complaining as regards the violation of the order not only passed by the learned trial court but also order passed by this court on 17/6/2016. This court had taken note of the orders passed by the learned trial court on 1/10/19, 4/10/19 and 24/10/19, as well as the order dated 23/10/19 passed by the learned trial court, learned first appellate court. In the opinion of this court, when there was a status quo order passed by this court on 17/6/2016, Lordship, kindly note the date. This is the date on which the Honorable High Court has passed the reimposes the second status quo again. Lordship, kindly note the date. This is the date on which the Honorable High Court has passed the reimposes the second status quo again. In the opinion of the High Court, when there was a status quo order passed by this court on 17/6/2016, any construction so made thereupon and thereby blocking the ingress and egress of the plaintiff through the Schedule B land amounts to violation of the order passed by this court, and as such, the constructions, if any, carried out more so during the pendency of the suit have been rightly directed to be demolished by the learned trial court in its order referred to herein above. Pausing here, my lord, but in this paragraph, there was an admission from our side, my lord, before the Honorable High Court, that yes, there were some construction of Tinsali house in the disputed area, my lord, by our side, when there was a vacation of the status quo order, and even till the time when it was reimposed, that was construction was there. And after that, there was no allegation also that we have constructed any such house or something. But this was during the period when there was no status quo order was operating, my lord. Thereafter, my lord, lordship in paragraph, same, I will continue, my lord. In 16, the Honorable High Court has granted certain directions. I will come down to clause 3 down, my lord, 16 subclause 3 at page 98, my lord.
Page number?
Page number 98 itself, my lord.
Yeah.
Continue paragraph 16, my lord. These are the directions. I'll
Yes, yes.
come to direction number 3 down below. This court further directs the learned trial court to cause a commission in terms of order 39 rule 7 of the code and thereupon ascertain as to whether the ingress and egress to the plaintiff's land in Schedule A of the plaint can be maintained without demolishing any of the structures so constructed. On, may I, my lord?
Yes.
On the basis of the commission's report, if it is found that the same can be done without demolishing any of the structure, the learned trial court said pass appropriate orders in that regard. Well, the first direction is that a commission will be caused to ascertain whether ingress and egress can be maintained without demolishing any of the structures that presents. And if so, my lord, the learned trial court will pass appropriate order. That is the direction at subclause 3. 4 says, in addition to that, this court further directs the Mangalore Police Station as well as the circle officer, Mangalore Revenue Circle to do the needful so that the order passed by the learned trial court for granting ingress and egress of the plaintiff to the Schedule B land to the Schedule A land from the municipal parts remains undisturbed during the pendency of the suit. This was the direction given, my lord, basically, to cause a commission, and we have to see whether ingress and egress can be maintained without, my lord, demolishing any of the structures present. And accordingly, my lord, learned magistrate will pass appropriate order. Pursuant to this, a commission was caused. Lordship, I have enclosed the commission report, Annexure 3, starts at page 100. Translated copy as page 101. Lordship, may kindly take up vernacular itself, my lord. Because translation, my lord, it's written may not be that correct also, my lord. Kindly take up the vernacular, read from a different page. Page 102 is the one.
Yes.
One second, my lord. Sir. My lord, I'll read that, my lord. মহোদয়, উপৰোক্ত বিষয় ও প্ৰসংগ সন্দৰ্ভত সন্মানীয় আদালতৰ আদৰ্শ মৰ্মে তলত উল্লেখিত তথ্যসমূহ অৱগত কৰা হ'ল। ৰঙামাটি মৌজাৰ মঙলদৈ বৰ্ধিত টাউনৰ 390 নং ম্যাদী পট্টাৰ 571 নং দাগৰ মুঠ জমি 2 কঠা 6 লেচা পাট্টাদাৰ ৰবিন দে। ৰবিন দে ইজ দ্য প্লেইণ্টিফ। পিতা সোয়েঞ্চো দখল কৰি থকা জমিত ঘৰ দুৱাৰ সাজি বসবাস কৰি আছে। উক্ত চৌহদৰ নিজ পকী বেৰ সংলগ্ন এখন লোহাৰ গেট উত্তৰ দিশত আছে যদিও সেই গেটখন বৰ্তমান বন্ধ হৈ থকা অনুসৰি উক্ত ফালেৰে প্ৰৱেশ অথবা ওলাই যোৱাৰ কোনো সুবিধা নাই। তাৰ সলনি চৌহদৰ দক্ষিণ পশ্চিম দিশত থকা প্ৰতিবেশী অনিল সূত্ৰধৰ পিতা পূৰ্ণসূত্ৰধৰৰ নিজা গৃহৰ উত্তৰ দিশেৰে উভয়ৰে মাজত থকা পকীবেৰ অৰ্ধভগ্ন কৰি অস্থায়ীভাৱে অহা যোৱা কৰি থকা দেখা যায়। So, my lord, report says there is an alternate way which he is temporarily using now, presently. I'll continue reading. আনহাতে ৰবিন্দে গোচৰৰ বৰ্ণনা কৰা পথৰ জমি হিচাপে একে মৌজাও টাউনৰ 402 নং ম্যাদী পট্টাৰ 572 নং দাগৰ মুঠ 1 কঠা 15 লেচা জমিত ৰেকৰ্ড মতে ক্ষেত্ৰমোহন দাস পিতা সয়ঞ্চো there are some names appearing নামত নামজাৰি থকা দেখা যায়। উক্ত দাগত দখলকাৰ হিচাপে পূব দিশত লভিতা দাস the petitioner hearing স্বামী মৃত কৌশিক দাসে ঘৰ দুৱাৰ সাজি বসবাস কৰি থকা দেখা যায়। আনহাতে পশ্চিম দিশত সুব্ৰত দাস পিতা মৃত চিত্তৰঞ্জন দাসে এটি ঘৰ সাজি দখলত ৰখা দেখা যায়। প্ৰকাশ থাকে যে ৰবিন্দে আৰু লভিতা দাসৰ সীমাত লভিতা দাসে পকীৰ চৌহদৰ বেৰ ও টিনৰ বেৰ নিৰ্মাণ কৰি ৰখাৰ লগতে সুব্ৰত দাসৰ অংশত এখন পকী বেৰ থকা দেখা যায়। তাৰোপৰি উক্ত চৌহদৰ দক্ষিণ ফালে লভিতা দাসে পুৰণি এটি গৃহৰ লগতে টিনৰ চালি সংলগ্ন কৰি ঘৰ সাজি বসবাস কৰা অনুসৰি উক্ত দাগত গোচৰ বৰ্ণিত অহা যোৱা পথ দেখা নাযায় আৰু বাকী অংশত লোহাৰ ৰডৰ অৰ্ধনিৰ্মিত খুঁটা থকা দেখা যায়। তাৰোপৰি উক্ত অংশৰ পশ্চিম কাষেৰে লভিতা দাসে মূল পথলৈ অহা যোৱা কৰি থকাৰ লগতে উক্ত দিশত থকা পৌৰসভাৰ পথৰ সংলগ্ন অংশত পকী গৃহ সাজি ব্যৱসায়িক প্ৰতিষ্ঠান ও টিনৰ বেৰ অৰ্ধনিৰ্মিত ইটাৰ গাঁথনি বেৰ থকা দেখা যায়। সেই অনুসৰি গোচৰৰ বৰ্ণিত অনুসূচী ক চৌহদলৈ অহা যোৱাৰ বাবে অনুসূচী খ চৌহদত থকা চৌহদৰ বেৰৰ লগতে টিনৰ চালি ও টিনৰ বেৰ আঁতৰাই নিদিলে পথ নাথাকিব। আনহাতে বিবাদী হিচাপে সৰজমিনত উপস্থিত থাকি লভিতা দাসে আমাৰ তদন্তকালত মৌখিকভাৱে সহযোগ কৰে যদিও তদন্তকালত যুগত কৰা যাৱতীয় নথিপত্ৰত স্বাক্ষৰ প্ৰদান কৰাৰ বিৰত থাকে। Well, this is the report given by the commissioner after commission as per order of the Honorable Guwahati High Court. Now the report says two things, my lord, to my understanding, my lord. Number one, there was an alternate road which the respondent is presently using through the adjacent land, and if we do not demolish that boundary wall and the Tinsali house, which, my lord, as per that High Court judgment we have constructed in a period, then, my lord, there will be no path. This report was considered by the learned trial court, and pursuant to this, my lord, then order was passed. That order lordship will find at page, my lord, 103 annexure 4. No, my lord. 107 annexure 5. Annexure 5, page 107, order dated 1/10/2024. Based on this commission's report, learned magistrate passed an order on 1/10/2024. Thereby, my lord, he has discussed elaborately. I'll directly come to the operative portion at page 114. Page 114, my lord. Paragraph number 26.
Yes.
Further, in light of the findings of the commission report, the court hereby directs both the parties to maintain status quo, especially with respect to the structures identified in the report on the disputed land. Within bracket, my lord, this is Schedule A. It should be Schedule B, in fact. And the existing ingress and egress to the plaintiff's land, no further construction, demolition, or modification of any structures on the identified portion of the disputed property is permitted. Accordingly, no obstruction should be created or removed that would affect the existing assets until further order from this court. My lord, this order of the Honorable Court was challenged by filing an CRPIO again by the respondent, Annexure 6, 116, my lord, and wherein, my lord, this order has been set aside by your lordship. My lord, 118, paragraph 6 is the operative portion. It appears from the plaint annexure 18 that the relief is being claimed in respect of Schedule B land plaint, but the learned trial court fight order dated 1/10/24 has directed to maintain status quo in respect of Schedule A land, in respect of which no relief is being claimed in the plaint. As submitted by Mr. Datta, Schedule A land is the property of the petitioner. That being the position, there is no question of granting status quo in respect of Schedule A land, and as such, the impugned order is arbitrary and illegal. In view of above, the impugned order dated 1/10/24 passed by so and so in title suit number 137 of 2013 stands set aside and quashed. Accordingly, matter is remanded back to the learned trial court to hear the matter afresh and thereafter to pass a fresh order. Therefore, my lord, that status quo order again gone and matter was heard, and my lord, impugned order that is at page 120, my lord, was passed on 15/5/2025, my lord. My lord, before I read this impugned order, I may point out another one thing, my lord. As we have read that there was a commission caused by the Honorable Guwahati High Court. Prior to that, my lord, there was another commission caused by the trial court itself in respect of the property. That also I have enclosed. That is, your lordship will get at annexure 4, page 103. This was much prior to that, my lord. The Honorable High Court directed to cause a commission. This report was submitted on 28/5/2018. Lordship, the vernacular portion will get at page 101.
On the
106, sorry, my lord. Pen 106. No, I said 101, my lord. It starts. Has your lordship got it?
Yes.
Well, I'll read. উপরোক্ত বিষয় সন্দর্ভত সন্মান সহকারে জনাও যে মহামান্য মুন্সিফ নং 1 আদালতৰ মিসকেস নম্বৰ so হুকুম মতে আজি 28/5/18 তাৰিখে ৰঙামাটি মৌজাৰ বৰ্ধিত টাউনৰ 402 নং ম্যাদী পত্ৰৰ 572 নং দাগৰ পৰা 10 ফুট বহল আৰু 80 ফুট দীঘলৰ ৰাস্তা এটি মুকলাই দিবৰ বাবে মংগলদৈ আৰক্ষী চকীৰ উপপৰিদৰ্শক মহোদয়ৰ লগত চৰজমিনলৈ যোৱা হয়। চৰজমিনত গৈ জোখমাখ কৰি দেখা যায় যে ওপৰত উল্লেখিত মংগলদৈ বৰ্ধিত টাউনৰ 402 নং ম্যাদী পত্ৰৰ 572 নং দাগে 1 কঠা 5 লেচা মাটি 4জন পাট্টাদাৰৰ নামত চলি আছে। পাট্টাদাৰ ক্ৰমে so প্ৰকাশ থাকে যে উক্ত মাটিত ভূমিলক্ষ্য নথিমতে গোচৰৰ একম পক্ষ ৰবীন্দ্ৰৰ নামজাৰি নাই। মেপত উক্ত দাগটোত কোনো ৰাস্তা অংকন কৰা নাই। কিন্তু মহামান্য আদালতৰ হুকুম মতে উক্ত 572 নং দাগৰ পূব সীমাৰ পৰা 23 ফুট এৰি 10 ফুট বহলৰ আৰু 80 ফুট দীঘলৰ ৰাস্তা এটি গোচৰৰ দুয়োপক্ষৰ সন্মুখত জোখমাখ কৰি মুকলাই দিয়া হ'ব। মুকলাই দিয়া ৰাস্তাটো ট্ৰেছ মেপত চিহ্নিত কৰি সংলগ্ন কৰা হ'ল। My lord, this report which was in 2015, it also says, my lord, as claimed there is no suit part, but will clear a path in presence of both the parties that will go at a after leaving 23 feet from the eastern side. They are claiming their path at the eastern boundary between dag numbers 572 and 573. It will cleanse, my lord. They have annexed one trace map with the plain rough sketch map which they have prepared. I'll give that also, my lord. Lordship, may kindly turn to page number 25. This is the rough sketch map along with the plain they annexed. My lord, Schedule A is DAG number 571. That is the land of the plaintiff, the respondent hearing. 572 is the DAG number and 573 is our land, which we have got by virtue of the decree in the suit and the appeal. And Lordship may kindly note the directions given north, south, east, west are there. My lord, the suit part, that shaded portion is towards the eastern side of DAG number 572, and it starts adjacent to the DAG number 573. Am I clear, my lord? This. Now, my lord, kindly turn to page number 106. The report that says, I will read the fourth line from the down. As you also got it. Fourth line from the down. কিন্তু মহামান্য আদালতৰ হুকুম মৰ্মে উক্ত 572 দাগৰ পূব সীমাৰ পৰা 23 ফুট এৰি 10 ফুট বহল আৰু 80 ফুট দীঘলৰ এটা ৰাস্তা দুয়োপক্ষৰ সন্মুখত জোখমাখ কৰি মুকলাই দিয়া হ'ব। Lordship, kindly turn to page 25 again, my lord. If we leave 23 feet from the eastern side boundary of 572, then, my lord, this footland is not there. This footpath is not there. It's a different footpath. Footpath is 10 feet from the eastern corner of DAG number 572 from the sketch map. Now, as per report which has been cleared by the commissioner earlier, that is after leaving 23 feet, it comes somewhere in the middle or towards the west, my lord. And both the parties in presence, this was in consent, this has been done. Because there was no road at all. That is why this arrangement was made. My lord, when this report was submitted, then on the immediately next day, there was again allegation that we have violated the injunction order, and this continues. Now, my lord, I will come again back to that, my lord, when this order dated 1/10/2024 was set aside, saying that injunction order should have been on the status quo, should have been on the Schedule B land, but it was in the Schedule A land, my lord. Thereafter, learned trial court passed the impugned order. My lord, that is it. Page number 120, Annexure 7, 15/5/2025. Operating portion, lordship will find at page 127. My lord, I'll read down below. Therefore, I deem it up to order that number 1, the tin sheet fencing, tin roof structures, and any other construction raised over the Schedule B land after the status quo order, which presently obstructs the ingress and egress of the plaintiff to his land described in Schedule A, are directed to be removed forthwith. My lord, I am disturbed with these tin roof structures, my lord. My lord, there are allegations that we have violated the status quo order, as I have already read how I have constructed boundary wall, tin fencing, etc., etc. There is a report saying that the petitioner with her minor daughter is residing in the land by constructing a tin sally house. From the commission report, my lord, I have read it. Am I correct, my lord? Before the Honorable High Court, when earlier round of litigation was going on, we said that when there was a vacation of the status quo order, there were some constructions, my lord. And we are residing there. By virtue of this order, my lord, our tin sally house is also directed to be demolished. Then, my lord, it says the circle officer, Mongoldoy Revenue Circle, along with officer in charge, Mongoldoy Police Station, is directed to ensure the execution of the order and to supervise the demolition activity. Adequate police force shall be deployed to maintain peace during the process. Defendants are directed to ensure full cooperation during execution. Any act of non-compliance shall be viewed seriously. Restoration of the pathway shall be completed within a reasonable time from the date of receipt of this order. Compliance report shall be submitted by the circle officer Mongoldoy immediately after execution of 15 days from the date of this order, and accordingly our date was fixed on 29/5/2024. After 15 days, my lord, during that span of 15 days, my house was, my lord, I am a widow living in that house with my minor daughter. My daughter is in class 11 now. My lord, as I have pointed in the plain, there are 17 defendants, but I am targeted and my house is to be directed to be demolished. I am disturbed with that, my lord. I filed an appeal before the first appellate court. Lordship will find that order at Annexure 8, 129 page. Order dated 26/5/2025 in Miss Appeal number 725, my lord. I will read, my lord. This is an order. In the third paragraph, Lordship says the appeal is admitted. As your Lordship got it, my lord. I will not read the entire order, my lord. Appeal is admitted, and my lord, thereafter, my lord, order for 41 Rule 5 petition, stay petition, my lord. This has not been granted. Last page at page 131. My lord, after considering the submission of learned counsel, I am reading the operative portion only at page 31. For the after considering the submissions of learned counsel for the appellant and after going through the case record and relevant provisions of CPC, I am not satisfied and there is any justified ground for stay of the operation of the impugned order dated 15/5/25 passed in Midze case number 147 of 13. Accordingly, the prayer of stay of the operation of impugned order is hereby rejected. My lord, agree by both this order, my lord. I have filed this petition, revision petition, my lord, wherein your lordship has protected our interest, my lord, by granting a stay. My lord, my submission is that, my lord, this order, as I have stated, my lord, there was no mention anywhere, my lord, that I have constructed a house in violation. That violation petition, my lord, my learned friend has filed a vacation petition. He has enclosed that petition also. Lordship, kindly take, I will read what is the allegation in their petition. You will definitely point out, my lord, but I will also try. This page 47 of the IA, my lord.
Yeah.
Page 47 of IA, my lord. This was under Order 39, Rule 2A. Lordship may kindly turn to page number 48. Para number 4. That on 10/11/2015, the opposite party number 2, that is the deceased husband of the present petitioner. Opposite party number 2 of Ms. J case number so and so, Sri Kaushik Das, suddenly dismantled and removed the bamboo fencing erected in both sides of Schedule B part. I'll read again. Suddenly dismantled and removed the bamboo fencing erected on both sides of the Schedule B part and threatened the petitioner plaintiff when the petitioner plaintiff requested him to refrain from doing such illegal act on the suit part. He removed the wooden post of the Schedule B part fencing and posts were there prior to filing of the suit. Again, the illegal act of the opposite party, the petitioner plaintiff filed the FIR number so and so Sadar Police Mahal on the same day of the incident, my lord. My lord, this is the allegation, violation. My lord, if I read it again, my lord, to my understanding, I understand, my lord, in the Schedule B part, there existed some fencing prior to this. My lord, he again says, I will read it again, my lord, if I have understood correctly, that on 10/11/2015, the opposite party number 2 of the Midze case 6 of 13, Sri Kaushik Das suddenly dismantled and removed the bamboo fencing erected on the both sides of the Schedule B part. Meaning thereby there were bamboo fencing were there and some fencing were there on both sides of the Schedule B part. And threatened the petitioner plaintiff when the petitioner plaintiff requested him to refrain from doing such illegal act on the suit part. He removed the wooden post of Schedule B part. The fencing of the post were there prior to filing of the suit. This fencing were there prior to filing of the suit. That is the statement. Against the illegal act of the opposite party, the petitioner filed FIR before Mangaldoi Police and so and so. My lord, there was no allegation saying that I constructed some house on the suit part that is to be demolished. No prayer at all, my lord. The only allegation they have brought that I have demolished the earlier wall and erected new. That is to be demolished. Now the commission report, which caused pursuant to the Honorable Guwahati High Court's report, order, it says there are concrete wall and tin fencing and also a tin sally house. If you do not remove that, then there will be no path. And accordingly, my lord, everything is directed to be removed. I am now, my lord, I am forced to, if that order is executed, my lord, if I am not granted any relief, my lord, I have to be on the road with my daughter, minor daughter. My lord, report also says High Court directed. The commission was caused. Why, my lord? I have read that paragraph 16. It says cause a commission to see if alternate spaces can be managed without demolishing the structure. Okay, my lord. High Court condemned construction of the structure, if any, in violation of the order. But says cause a commission to see if alternate spaces can be managed without demolishing the structures. And accordingly, order will be passed. My lord, I'll read that portion again and again, my lord. High Court's order, my lord.
So, Sharma,
Yes, my lord.
will receive after 5.
I just want to revisit that direction issued by Honorable High Court in earlier, my lord. I will be summarizing, my lord. Thereafter. Lordship, may kindly turn to page number 98. That earlier under litigation's order is starts at page 89, and I will be reading page number 98.
Yes.
My lord, 98 paragraph 16, the subclause 3 down below. This was the direction given by High Court earlier.
Paragraph number 98.
No, page number 98. Paragraph
Page
number
number 98,
16.
yeah.
Paragraph 16,
In IA or main,
my lord.
you are referring to IA or in main?
I'm referring to the CRP, my lord. Main petition.
Yeah.
98, 16 down below the subclause 3. This was the direction given. This court further directs the learned trial court to cause a commission in terms of order 39 rule 7 of the code and thereupon ascertain as to whether the ingress and egress to the plaintiff's land in Schedule A land of the plain can be maintained without demolishing any of the structures so constructed. The purpose of commission, appointment of commission was that go and see kindly if any other road is there. On the basis of the commission's report, if it is found that the same can be done without any demolishing of structures, the learned trial court shall pass appropriate orders in that regard. In addition to, police has been directed, my lord. The operating portion is clause 3. Commission will be appointed. It will see if it is feasible, then there will be an appropriate order by the learned magistrate. Now, Lordship may kindly turn to that report. Kindly turn to that report, my lord. My lord, I will be reading from the top. Rangamati Mozar at page number 102, my lord.
Yeah.
Page 102. This is the commission report. My lord, from the top. My lord, Rangamati Mozar Mongoldoy Bordito Townor Imanong Patta Imanong Zomi Patta the Robin Day Uparanjan Day Dokol Kuri Toka Zomi Hordwar Haji Bokova Kuri Ase Aru Ukto Sohodor Niz Poki Bear Honglogno এখন লোহার গেট উত্তৰ দিশত আছে যদিও সেই গেটখন বৰ্তমানে বন্ধ হৈ থকা অনুসৰি উক্ত ফালেৰে প্ৰৱেশ অথবা ওলাই যোৱাৰ কোনো সুবিধা নাই তাৰ সলনি দিস ইজ ইম্পৰ্টেণ্ট মাই লৰ্ড তাৰ সলনি চৌহদৰ দক্ষিণ পশ্চিম দিশত থকা প্ৰতিবেশী অনিল সূত্ৰধৰ নিজা গৃহৰ উত্তৰে উত্তৰ দিশেৰে উভয়ৰে মাজত থকা পকীবেৰ অৰ্ধভগ্ন কৰি অস্থায়ীভাৱে অহা যোৱা কৰি থকা দেখা যায়। If we go by the order of this Honorable High Court, that if there is any arrangement can be made, my lord. This is the answer, my lord. Commission report says he has been using. Down below, my lord, he has mentioned everything. And my lord, I'll not read again, my lord. There it says, if we do not demolish the fencing and thin roof structure, my lord, then there will be no passage through this. My lord, so therefore, my lord, I may humbly pray, my lord. There can be an order, my lord, ought to have been an order by the London Magistrate to maintain status quo as they were using the egress and egress through that particular portion of adjacent land that can be maintained till finalization of the suit. And my lord, this house that has been constructed, my lord, was not in violation of the status quo order. There is no allegation at all, as I have read, my lord. Allegation is that we demolished the existing fencing and we started constructing boundary fencing. Nowhere there is allegation, my lord, that tin-solid roof was. That is our admission before the Honorable High Court that yes, there are some concerns because that arrangement has to be made because of some family problem, my lord. Again, my lord, I say the right, title, interest, and position over the suit land now, we got it in August 2012. And the present plaintiff, the present respondent, my lord, he filed the suit in 2013, claiming right of adverse position on us. My lord, to claim right of adverse position, there has to be a position of 12 years against my interest, my lord. My lord, when I got in 1 year before, this plaint, my lord, per se not maintainable at all. If, my lord, this plaint is not maintainable, prayer of the plaint is not maintainable, how the injunction order can be maintainable, my lord? So, my lord, the impugned order 15/5/2025, the learned magistrate has passed to demolish, may kindly be interfered with on these two grounds, my lord. The plaint is not maintainable, number one, my lord, because of this. Honorable Guwahati High Court on earlier set of round of litigation said commission should be caused to see whether there can be any arrangement without demolishing the structure. And the report said yes, they are using it. So they will continue this during pendency of the suit. If in the suit they win, that is different thing, my lord. Thirdly, my lord, I have also filed an appeal, statutory appeal, my lord. As I have pointed, my lord, the statutory appeal has also been admitted, but I am not granted stay, my lord. But if that is allowed to be continued, my lord, then appeal will also become infructuous. On these three counts, my lord, the impugned order is liable to be interfered with, my lord, that is to be set aside, my lord. Well, right to life and liberty, my lord, 21 has some priority, my lord, over all these, my lord. I am residing on my Patta land. Everywhere I am saying there is no road, no road. Report also says so. There is no allegation I constructed house, but house has been directed to be demolished, my lord. That cannot be, my lord, to my understanding, my lord. And that is my humble submission, my lord. My lord, the lordship has already passed an interim protection in our favor, my lord. That has been, my learned friend has filed a vacation petition saying that I have misplaced and placed the tutored facts, my lord. I'll reply to that, my lord, if required, my lord.
Okay.
Problem. No. Yes.
Wait, please, your lordship. My lord, I'll start from the IA, my lord. My lord, the IA may be taken as my objection, as our objection to the CRP. And taking the IA, my lord, I will just place a short list of dates, my lord, so that the matter can be projected within a very short campus. Now, my lord, your lordships have seen the suit which my learned friend has referred to from the CRP. If your lordship will kindly come to page 27, where a projection has been made that as if the suit is for grant of adverse possession. my respectful submission in that regard will be, my lord, it is not only a case for grant of adverse possession simpliciter. It is basically a case for grant of my easementary right. Your lordship will kindly come to page 27 of the IA. I will draw your lordship's attention to paragraph 6.
Yes.
Paragraph 6 in the IA, my lord, page 27, paragraph 6. The plaintiff is entitled to a right of way from their house over the path to the municipal road situated to the north of the plaintiff's house, as shown in the rough sketch map annexed to the plaint. The said path is being utilized and used by the plaintiff and their men for the last 62 years without obstruction or any interference whatsoever from any person whatsoever, openly as an easement and as of right. This is paragraph 6 and 7. And now if your lordship will kindly see the first prayer at page 30. The first prayer is for a decree declaring that the plaintiff has an easement right on the said path described in the Schedule B or below the plaint. So it is not a case that my suit is for a decree of adverse possession simpliciter. Whether or not I am entitled to adverse possession, whether or not I succeed in proving adverse possession, well, that is another aspect of the matter. That is one limb of my relief. But the other limb is grant of easementary right. Now, the submission that has been made by my learned friend that the suit itself is not maintainable and therefore there is no question of grant of status quo and grant of an interim injunction, that cannot be gone into at this stage, principally for two reasons. First of all, the order of status quo has been upheld finally by this honorable court in the previous round of litigation. Well, it has been repeatedly shown to your lordship, particularly para 15 of the previous judgment. If your lordship will kindly come to page 120, page 90, page 126 of the IA, my lord. And the particular observation your lordship will find at page 134. And the first.
Yes.
And the first subparagraph of paragraph 16 at page 135. The order dated 26th March 2015, passed by the learned trial court in miscase number so-and-so is restored. Well, 26th March 2015 was the injunction order. Now, this has been restored by this honorable court in the first very paragraph. How can now it be argued that the suit is not maintainable and therefore the injunction order cannot be maintained? Well, this order has attained finality. There is no further challenge to it. Therefore, my respectful submission is that the submission that the injunction order is not maintainable and the plaint itself is not maintainable, these are misplaced submissions. Neither tenable on facts nor on law. Because it was an inter-party order in which the petitioner had taken part, and this was observed by this was finally decided by the honorable court, that the injunction order is restored. His challenge to the order of injunction was rejected. His challenge to the injunction order was rejected. The appellate court's order in his favor, by which the injunction order was interfered with, that was set aside. So, at the end of the day, my lord, today, where does he stand to say that the suit is not maintainable and the injunction order is not maintainable? So, these submissions are outright liable to be rejected. The second sentence in the very first paragraph, my lord, the order passed by the learned first appellate court dated so-and-so, passed in miss appeal number so-and-so, is set aside and quashed. It was their appeal. which was preferred against the interim order, interim injunction passed on 26th of March. Now, second paragraph, your lordship will kindly consider. This court is not inclined to interfere with orders dated 1/10/2019, 4/10/2019, and 24/10/2019. All these orders were passed in response to my petition challenging violation of the status quo order in one manner or the other. Now, all these orders were put to challenge, and all these orders were not interfered with by the High Court. Therefore, my lord, in my respectful submission, it is too late in the day to now contend that I have got my house over there, I have got my this over there, that over there, and therefore the order should be revisited. Now, if your lordship will kindly consider the sketch map, page 33.
Page number?
Page number 33. My lord, I am referring from the IA only, my lord. So, and that's why, my lord, I have given a list of dates, my lord, which contains the page references. Now, in page 33, my lord, 571 is 571 is my dag, and 572 and 573 belongs to them. My lord, it has been projected to your lordship that there was a suit in which these two dags were subject matter and they ultimately got a decree. There is no dispute over that. What I am asking for in the suit filed by me is my right of easement over a strip of land which runs through these two dags. They have said that there is no land. Naturally, my lord, there is no path. They have shown to your lordship the first report of inspection which shows that there is no there is no path described in the map. Naturally, my lord, it will not be there because I am claiming my easementary right. Had there been a path described over the map, my lord, there would not have been any necessity to file a suit for declaration of my easementary right. Had there been a road in between, my lord, there would have been no necessity of filing the suit. So naturally, in the trace map, the path will not be shown. I am asking for my easementary right over a strip of land which runs through these 572 and 573. Now, much has been said about the existence and boundary and the construction and etc. My lord. The meat of the matter remains whether or not there have been any construction over this strip of land on which there was an injunction on 26th of March 2015. That is the meat of the matter. If you have carried out any construction over this strip of land at measuring 85 feet by 10 feet in violation of the order of injunction, then it has to go. The alternative path that the Honorable High Court has suggested in the order of 22nd March 2024, that is, if this path can be maintained without demolishing any of these structures. It cannot be understood to mean that if I have found out a subsequent route through somebody else's house, then that should be considered as an alternative route. Otherwise, what is the meaning of the injunction order? If every time he keeps on creating obstruction on the strip of land over which I have been asking for declaration of my easementary right, what is the purpose that the injunction order should be there? Every time I will be asked to visit through somebody else's house and find out a way for myself. That cannot be the object of the order of the court. Now, what he has done, my lord, I'll just take your lordship through the list of dates. 26th of March, your lordship has seen the order of injunction was passed. And 6th of February 2016, I had filed a petition alleging that it was violated. That petition is at page 47. My learned friend has referred page 48 to your lordship, my lord. So what initially it was done, if your lordship will kindly have the sketch map in focus, my lord, it will be convenient for me to communicate, my lord. If your lordship finds that 571 towards the eastern side, sorry, towards the northern side, my lord, my exit is through the northern side of my plot of land. So he initially the husband of the petitioner, he initially carried out certain constructions here, certain diggings here. Initially put a put a gate in front of my exit towards the north. Those became subject matter of concern in the violation petitions. Now, the moment this was done, I filed a petition. This was removed. He did something else. He started digging the path. Now, after that was complained, that was remedied, then he started something else. If your lordship will kindly go through the list of dates, my lord, it will be very much visible, my lord. Your lordship will kindly find the order of the trial court at page 67, dated 19th of May 2018. Has your lordship got it, my lord?
Yes.
Well, I am reading from the second paragraph. Seen certified copy of the order dated so and so. Or it is not numbered, my lord. Just the second ones. Has your lordship got it?
Yes,
my lord?
yes.
Seen certified copy of the order directing both the parties to maintain status quo with respect to the suit path. Hard submissions advanced by learned counsel appearing for the petitioner. From the submissions and the documents supplied by the petitioner, it appears that the opposite parties are causing disturbances in violation of the status quo order dated so and so, despite the fact that the said order is still effective and in operation. The opposite parties have not complied with the said order, and therefore, in my opinion, if the status quo order dated so and so is not executed forthwith with the assistance of police personnel, then the overt acts of the opposite parties will result in alteration of the suit path to the utter detriment of the petitioner. Hence, petitioner's prayer by petition number so and so is allowed. The above status quo order dated so and so shall be executed through SP Dorong. Thereafter, my lord, the directions were issued and an order was issued to the SP to execute the order. Now, in compliance thereof, my lord, page 70 is a communication issued by the Mongoloi PS police station in charge. Now, he says, in inviting in reference to the subject cited above, I have the honor to report that as per your order dated so and so, the status quo order has been executed to remove the detrimental objects found over the suit path measuring 10 feet in breadth, 80 feet in length, out of an area of 1 cut of so and so, covered by dag number so and so, in so and so, submitted for favor of your information and knowledge. Therefore, as late as on 28th of May 2018, the suit path was cleared. Till then, my lord, there was no story of any house having been standing on the suit path. Now, how the story of house has been created, my lord? Well, it has been said that there is no allegation from the side of the plaintiff that any house was created or house was erected. And therefore, my lord, the order is utterly untenable because there was no house was in projection. Now, as against that, my lord, your lordship will kindly see 28th of May, even the respondents, the defendants also do not say that there was any house which was cleared on 28th of May 2018. Thereafter, how the story of house has come. Now, if your lordship will kindly go back to page 33 once again. What they have done mischievously is this, my lord. You have seen, your lordship will kindly see the boundary of the 572, my lord, the sketch boundary. I don't mean that this is the exact boundary. The sketch boundary of side 572 towards the eastern side. Has your lordship seen that in the... Now, what they have done, see, this is the boundary of his house, and this is the strip running through 572 and 573. So, what they have done, they have constructed a tinchali over here, just to block the passage. It's a 10 feet width passage, not much. So just on the eastern boundary of their dag, they have erected a tin shed, thereby converting it into a room. This is the mischief that they did. And about this, there is an admission by their counsel in the previous round of litigation that your lordship has seen. Now, how this has come into existence, my lord, I will just show to your lordship, my lord. The lordship will kindly come to page 74. Page 74. Sorry, 73.
Yeah.
It is in vernacular, my lord, the last few lines. প্রকাশ থাকে যে উক্ত মাটিত ভূমিলেখ্য নথি মতে গোচৰৰ প্ৰথম পক্ষ ৰবীন্দ্ৰৰ নামজাৰি নাই. Naturally, it will not be there, my lord, because I am claiming my easementary right through somebody else's land. মেপত উক্ত ডাকটোত কোনো ৰাস্তা অংকন কৰা নাই, কিন্তু মহামান্য আদালতৰ হুকুম মৰ্মে 572 দাগৰ পূব সীমাৰ পৰা 23 ফুট এৰি 10 ফুট বহল আৰু 80 ফুট দীঘলৰ ৰাস্তা এটি গোচৰৰ দুয়ো পক্ষৰ সন্মুখত জোকমাক কৰি মোকলাই দিয়া হ'ব. মোকলাই দিয়া ৰাস্তাটো ট্ৰেছ মেপত চিহ্নিত কৰি সংলগ্ন কৰা হ'ল. This was done way back in the year 18. And on this pillar, your lordship has seen the execution. The execution was also on 28th of May. To the report on execution was 28th of May. This was also drawn on 18th of May. So, this clearly indicates that as on 2018, May 2018, there was no story of house, no story of tin chali. Thereafter, your lordship will kindly come to page 74. This is my second petition before the trial court. Seen petition number so-and-so submitted by, filed by petitioner so-and-so under so-and-so, with documents submitting that the opposite parties have erected a wall on the footpath, thus preventing his egress and ingress altogether. This wall was created on the northern boundary of my Schedule A land. My Schedule A land opens to the footpath. Hence, he has prayed for removal of the concrete wall that was erected by the opposite party. Perusal of the case record discloses that the opposite parties have been causing disturbances on the footpath despite order from Honorable High Court. Wide order dated so-and-so ordered opposite parties to refrain from causing disturbances on the footpath. Again, wide order of this court dated 19th May 2018, the status quo order was directed to be executed. Said order was duly executed and compliance report thereof shows that the execution was done in presence and with the consent of the opposite parties. Today, the petitioner has again sought intervention of this court in removing the disturbances caused by the opposite parties. Case record discloses that the path concerning which the opposite parties had allegedly erected the wall after execution of the order dated so-and-so is the subject matter of the suit. Therefore, preservation of the suit path as it was on the date of filing of the suit is absolutely essential for the trial court to arrive at a just adjudication. Moreover, the documents, that is photographs of the suit path relied upon by the petitioner, shows that the suit path has been completely obstructed by the opposite parties by their overt act of construction of concrete wall, thus at the same time entirely preventing the petitioner from egress and egress to his homestead. I am taking a pause here. This is the reason, my lord, I had to find out an alternative path through the land of Mr. Sutrodhar, about which there is a mention in the subsequent report. Because he had completely blocked the footpath. Therefore, I had to find out some way to get out of the house, my lord. I requested my another neighbor, my lord. He has now allowed me a temporary strip of exit through my posterior boundary that I have been using now. Also seen the report from the OC Mongoldoi, which also shows that the opposite parties had blocked the footpath entirely by erecting a concrete wall. My lord, this is the concrete wall about which, my lord, your lordship will find a mention in the previous order of the Honorable High Court, which is at page 134, paragraph 15, where we had also said that this is how it was obstructed. Now, in between, there is another, every time, my lord, the proceeding takes a direction here and there, my lord, there is new and newer means to block the path. Now, will your lordship, in my respectful submission, will your lordship permit a litigant to flout the order of not only of the trial court, but of the dishonorable court in a manner he likes? And can a person like him, my lord, who is a habitual offender, I will say, in violating the orders of the court, be it trial court, be it the high court, will your lordship give him a hearing to contend that his life is at stake or his livelihood is at stake, Article 21 is at stake?
Your word offender.
No, my lord.
appears to be-
My lord, it is not my word, my lord. The honorable courts have recorded the finding that frequently he is creating this.
Maybe, but this word offender, it's
My lord,
to be.
my lord, even if your lordship, my lord, I bow down to your lordship, my lord, even if my wording is not correct, my lord, the order of the trial court shows, coupled with the order of the honorable high court, that he has been doing it. Not only once, my lord, repeatedly. The instances are more than once. Now, if your lordship permits me to read from the page 134, my lord, paragraph 15, about fifth line, my lord. On the other hand,
Paragraph number?
15.
Yeah.
About fifth line, my lord, in the paragraph 15. On the other hand, Mr. So-and-so, counsel for the plaintiff, submitted that the defendants raised construction by constructing a wall as well as blocking the ingress and egress for which proceedings as a so-and-so was initiated. Well, this statement, my lord, I am referring because your lordship will find a echo of it in page 75. Page 75 practically, my lord, the submission is practically based on what was recorded by the honorable court in page 75. Now, may I read from page 75 further, my lord? Therefore, from the observation and discussion made above and the documents, has your lordship got it, my lord?
Yes.
And the documents submitted by the petitioner and the report from the OC Mangaldoy, it occurs to me that the opposite parties have willfully erected the concrete wall with an oblique motive of frustrating the suit. Now, I may just say, my lord, this 1/6/2018 order this 1/6/2018 order was passed in a separate miss case. Your lordship, at page 74, your lordship will find a number of the miss case. It was miss case number 15 of 2016. Because the first violation order, the first violation petition was miss case 6 of 2013. About which, my lord, there was an execution which was completed by report of execution at page 70. Has your lordship got it, my lord? Now, this page 74 order emanates from a subsequent petition. Therefore, my lord, the submission that has been advanced by showing to the first petition that there was no whisper about the house and all, my lord. The reason is this, my lord, because the first order was not, the first violation petition was not concerning anything else but creation of disturbance on the suit path by removing post, by removing boundary fencings, etc. That was done away with, and thereafter this fresh petition was filed when he erected a wall. That was the second instance of his violation. Now, therefore, my lord, finally the honorable court directed the SP Dorong to execute the order in presence of witnesses, and it was at that stage, my lord, ultimately the further proceedings were to be taken in the miss case on 1/10/2019. That is, your lordship will find at page 77. Now, as I have shown to your lordship, my lord, first there was miss case 6 of 2013 alleging violation. The second was miss case 5 of 2006 alleging violation. This was 15 of 2018 alleging violation. And here, my lord, at page 78, your lordship will find the reference of the miss case. Second paragraph, my lord, as such.
Yes.
As such, the main suit, TS number so-and-so and the instant case, Ms. J 15/16, filed under order so-and-so, are also pending for disposal. Now, in the meantime, in the present case, the petitioner, White petition number so-and-so, has filed an application under so-and-so to give similar kind of direction as passed by order dated 19/5/2018, 1/6/2018 by my learned predecessor, and to remove the barricades and concrete wall erected over the footpath, to restore the footpath as on the date of the passing of the status quo order. The petitioner has contended that on so-and-so wife of the deceased so-and-so had obstructed the footpath and erected barricade and made of bamboo and tin. This is important, my lord. This barricade of bamboo and tin is nothing other than the tin chali, which was erected on the eastern boundary of their existing house. Tin on the entry and exit point of the footpath, and also constructed concrete wall on the entry point of the footpath, and therefore it has become impossible for the petitioner and his family for ingress and egress through the footpath. Accordingly, wide order dated so-and-so, the OC Mongoloi was directed to submit a report as to whether the opposite party had committed any breach of the status quo order dated so-and-so, which was directed to be maintained by Honorable High Court. Now, as against this, my lord, this particular observation is very prominent at page 79. About fourth line from top, the paramount consideration at this juncture is that the status quo order, which was passed by the trial court on 26th of March and affirmed by the Honorable High Court, wide order dated so-and-so, has been complied with by the both parties, and there is no violation of the status quo order. The OC has also enclosed a letter with his report, which is addressed to the circle officer so-and-so for praying for deputing Latmandal and sufficient staff for ascertaining the footpath. However, it appears that the letter was sent to the circle officer so-and-so as short notice, just a day before submitting the report. Moreover, in the report of the OC Mongoloi, there is no mention whether the circle officer had deputed Latmandal and staff in compliance of the prayer made by the OC concerned. Further, the OC Mongoloi has submitted in his report that an old gate is blocked by a concrete wall and tin. Now, from the perusal of the photographs appended by the OC concerned, it clearly transpired that there is a concrete wall and tin barricade which have been constructed on the side of the opposite party, blocking the gate which is on the side of the petitioner. Thus, the report of the OC concerned reveals that the footpath has been obstructed by the opposite party by making constructions. This is the construction, my lord, about which, my lord, they had admitted in the previous round of litigation before the Honorable Court. Now, if your lordship will kindly see the report based on which, my lord, the order of the learned trial court was passed. That will be at page 144. My lord, may my lord may kindly see the vernacular at page 147.
Yes.
My lord may kindly mark from this wordings prokakh thake je. It will be about middle 10 lines from top. Just after the names of the parties.
Yes.
Prokakh thake je Robinde aru Lobita dakhor khimak. Lobita dakhe poki chouhodor ber ও টিনৰ বেৰ নিৰ্মাণ কৰি ৰখাৰ লগতে সুব্ৰত দাসৰ অংশত এখন পকী বেৰ থকা দেখা যায়। তাৰোপৰি, দিছ ইজ ইম্পৰ্টেণ্ট, মিলক দিছ পাৰ্ট, তাৰোপৰি উক্ত চৌহদৰ দক্ষিণ ফালে লভিতা দাসে পুৰণি এটি গৃহৰ লগতে টিনৰ চালি সংলগ্ন কৰি ঘৰ সাজি বসবাস কৰা দেখা যায়। As I have submitted before your lordship, my lord, what they have done, There is already an existing house, my lord. They simply have extended it by constructing this tinchali. আৰু ঘৰ সাজি বসবাস কৰা অনুসৰি উক্ত দাগত গোচৰ বৰ্ণিত অহা যোৱা পথ থকা দেখা নাযায়. That means, my lord, my lord, this construction, যে পুৰণি গৃহৰ লগতে তিনচালি সংলগ্ন ঘৰ. If your lordship will kindly remember the execution report of 2018, wherein, my lord, a path measuring 10 feet and 80 feet was cleared. Lord, it is more than apparent that this tinchali was not in existence then. It has been created for the first time after the execution was carried out. And about which, and that's why, my lord, it is identified here as পুৰণি এটি গৃহৰ লগতে টিনৰ চালি সংলগ্ন কৰি ঘৰ সাজি বসবাস কৰা অনুসৰি উক্ত দাগত গোচৰ বৰ্ণিত অহা যোৱা পথ দেখা নাযায়. So the path has been blocked by creation of this tinchali house. আৰু বাকী অংশত লোহাৰ ৰডৰ অৰ্ধনিৰ্মিত খুঁটা দেখা যায়. তাৰোপৰি উক্ত অংশৰ পশ্চিম কাষেৰে লভিতা দাসে মূল পথলৈ অহা যোৱা কৰি থকাৰ লগতে উক্ত দিশত পৌৰসভাৰ সংলগ্ন অংশত পকী গৃহ সাজি ব্যৱসায়িক প্ৰতিষ্ঠান ও টিনৰ বেৰ অৰ্ধনিৰ্মিত ইটাৰ গাঁথনিৰ বেৰ থকা দেখা যায়. সেই অনুসৰি গোচৰ বৰ্ণিত অনুসূচী কৰ চৌহদলৈ অহা যোৱাৰ বাবে অনুসূচী কৰ চৌহদত থকা চৌহদৰ বেৰৰ লগতে টিন চালি আৰু টিনৰ বেৰ আঁতৰাই নিদিলে পথ নাথাকিব. So this tinchali is particularly created, my lord, to obstruct my exit and entry through Schedule B path, Schedule B suit path. And naturally, my lord, this was not in existence in the year 2018 also. Because 18, the path was created. Now, if path was made clear, now kindly see the basic thrust in the petition is that, my lord, this is her only residence. Now, what she has, or rather her predecessor has said before the trial court in the WS, your lordship will kindly come to page 104, that is the WS filed in the suit.
Yes.
Their whole case is that, my lord, 572 and 573 dag, these are all covered by a boundary from all sides, and there is no suit path in between. That is their case. But in saying that, my lord, what they have also stated, the third line, the allegations made in the para that towards the eastern side of the path, there are residential house of defendants number 1, 2, and 3 are not wholly true and correct. In fact, my lord, this is important. In fact, towards the eastern side of dag number 572, the dag number 573 is situated where the defendants have their residential house. So in the suit, they have pleaded that their residential house is rather on the dag number 573, not on 572. My lord, a bare eye comparison with the sketch map at page 33 will make it clear, my lord. It is not even a statement in the trial. Not even their pleaded case in the trial that over the 572 dag, they have their homestead. Rather, they are saying that their homestead house is situated in the 573 dag. So the projection that has been made in the revision petition, that if the order of injunction is to be carried out, then they will lose their house. Well, that is not factually correct. That is their only house will be taken away, only house will be demolished. Well, that is not factually correct. And the emphasis that has been made to the Honorable Court's order, particularly subparagraph 4. Huh? Subparagraph 4 to? Eta? Subparagraph 3. Page 135, my lord.
Yes.
Well, much emphasis has been laid on this, my lord. This court further directs the learned trial court to cause a commission in terms of so and so, and thereupon ascertain as to whether the ingress and egress to the plaintiff's land in Schedule A of the plaint can be maintained without demolishing any of the structures so constructed. So two things are very clear, my lord. From the pleading and counter pleading of the parties, my lord, two things are very clear, that in violation of the order of the status quo, structures were created over the footpath. And because of the structures created, the ingress and egress of the plaintiffs from their footland has been obstructed. These two things are clear. Only thing that the Honorable Courts asked the trial court to look into is whether the entry exit, the free entry exit can be maintained without demolishing the without demolishing the structures. The creation of these structures are not in any doubt. It is their admitted case that though there was an order of interim injunction, we violated it with impunity and we created structure. But Honorable Court said that to ascertain whether it is possible or not. Now this possibility, my lord, as on date, my lord, as has been submitted by the petitioner side, my lord, as on date, my lord, I have been maintaining my access through somebody else's house. He has been kind and therefore I have been able to maintain it. Well, tomorrow if he for some reason closes the door, my lord, then I will be having no entry and exit to my homestead. And my lord, it is my pleaded case in the trial that I have been using this strip of path for last 62 years. For last 62 years, I have been using this footpath. My lord, that is my pleaded case. And considering this, my lord, balance of convenience, irreparable loss, etc., my lord, the interim order.
But Mr. Doctor, there is a report of the commission. As per that commission, there is no footpath.
Naturally, my lord. Naturally, my lord, if I am asking for my easementary right through somebody else's land, naturally there will be no footpath.
No. Then how you are using that footpath?
No. His report is that in the trace map that the revenue department maintains, my lord, in the trace map there is no footpath. I mean, there is no path. It is not footpath. There is no path. My lord, if I am having access to my land through somebody else's land, my lord, naturally his right, title and interest has been declared. Okay, fine. I am not saying that this is my land. It is his land. I am only ascertaining my right of entry and exit through a strip of land which falls between the two plots belonging to them. And that is the first commission's report. And not only that, my lord, first commission report says in two things very clearly. First of all, there is no path. There is no path to the Schedule A land except this. This is also a projection coming from the first commission report. My lord, if your lordship will kindly bear with me, lord, page 73 is the first commission report. Sorjominot has your lordship got? সরজমিনত গৈ জোখমাপ কৰি দেখা যায় যে ওপৰত উল্লেখিত মঙ্গলদৈ বৰ্ধিত টাউনৰ ইমান নম্বৰ মেয়াদী পাট্টাৰ ইমান নম্বৰ দাগে 4জন পট্টাদাৰৰ নামত নামজাৰি চলি আছে। পট্টাদাৰজন 4 ক্ৰমে ইমান প্ৰকাশ থাকে যে উক্ত মাটিত ভূমিলেখ্য নথি মতে, ইট ইজ এজ পাৰ দি ৰেভিনিউ ৰেকৰ্ড, ভূমিলেখ্য নথি মতে গোচৰৰ নামৰ নামজাৰি নাই। Naturally, it will not be there because 572, 573 both belong to them. Mapot ukto daktut kono rasta onkon kora nai.
How you are using for last 62 years as per your planning?
through their land, my lord, as now I have been using through somebody else's land, my lord. Today I am using it through somebody else's land because they have obstructed my right now. Tomorrow, my lord. Oh. Because 2012, my lord, as per their own demonstration, my lord, 2012 they got a right title and interest over this plot of land by virtue of the decree passed by the trial court, confirmed by the appellate court. Their right title interest over the DAG number 572 and 573 was declared in the year 2012. Before that, it was not their right. So naturally, since as now I have been, because of the circumstances, I have been now using my right of exit and entry through somebody else's land, my lord. Like it's about my easementary right. Easementary right presupposes that, my lord.
That will be decided by the trial court.
Now, therefore, the question is, the trial court will decide it in the full length trial. In the interim, trial court has protected my right of entry and exit by virtue of an interim injunction, and that injunction order has been affirmed by this honorable court. That
We'll see whether there is any violation or not.
no, my lord, they are not questioning the issue of violation. They are now questioning that whether in the name of maintenance of the injunction order, this tin shed can be removed. That is their subject matter of concern. So my respectful submission in this regard is this, my lord. Lord, it is apparent from the record, my lord, this tin shed, which is subject matter of dispute now, my lord, this was not in existence. My lord, the records are very clear about this.
That is
And if they have,
already admitted that it was not there earlier.
yes. Now, question, therefore, my respectful submission, my lord, the question that will fall for your lordship's consideration is this, my lord. Admittedly, my lord, there is a violation of the status quo order because it was not there. It was created after passing of the injunction order for whatever circumstance. Now, somebody who has violated the order of status quo, whether that he should be given some equitable consideration or not.
That is well, that when equitable consideration can be given or
Yes.
cannot be given.
Now you are a guilty of non-compliance first. First, you are a guilty of non-compliance. Now, whether you can ask for an equitable consideration or not. Only thing, Lord, one decision I would like to place for your lordship's consideration that I have missed out now. Within, my lord, half an hour, my lord, I'll supply it to him. It was a case, my lord, where an injunction order was there, and the injunction order was violated by the opposite party, saying that the trial court did not have jurisdiction. The matter went up to Supreme Court, and then the Honorable Supreme Court observed that if there is an order against you, we must first comply with the order, and then you can be hard complaining against it. Well, that I'll just supply.
My lord, lordship will allow me, I have to react to what has been submitted, my lord.
No, Mr. Since long we have been hearing this matter,
No, my lord, no.
I don't think
I'll take only 5 minutes. I'll take only 5 minutes, my lord. Only 5 minutes, my lord. Because, my lord, my learned friend has said, senior friend has said, my lord, that we have prayed for easementary right, my lord. Easementary right, my lord, to my understanding, if it is adverse possession 12 years, easementary right it is 20 years.
That will be decided by the trial.
Yes, my lord.
Not by
Yes.
this court.
Second thing, my lord, the report as page 70 of the IA has been read out and says that 10 by 80 feet road is cleared. That is after leaving the 23 feet. That has been missed out, my lord. Because this report at page 70 encloses the report of the circle officer, which is at page 73. It says, as per order of the court, we cleared a road of 10 by 80 feet after leaving 23 feet from the eastern corner. But their strip of road or that projection in the is at the eastern corner of the DAG number 572, as per the tracement. Well, logically, if now permits, my lord, I will place that only, my lord. Yes. That is not, my lord, if I have understood correctly, my lord, page 70 may kindly see, my lord, of the IA. I'm sorry, my lord, but
Yeah.
Yes, my lord, page 70 it says, this is a report given by the submitted before the court, saying that in inviting reference to the subject cited above, I have honor to report that as per your order dated so and so, status quo order has been executed to remove the detrimental objects found over the footpath measuring 10 feet by 80 feet in length out of an area of 1 katha 5 lesas covered by patta number 402, Doug number 522 or 572 in Doug number so and so, submitted in favor of current confirmation, enclosed. Report submitted by Circle Officer Mongoldoy, sketch map and 2 photographs. Now, I will continue with this. Page number 71 is the signal given. 72 is the translated copy of page number 73. This is the Circle Officer's report submitted along with this. My lord, I will read after the names. Prakash thake je, my lord, in the middle. Prakash thake je ukta matit bhumilekho nothimote বছৰৰ একপক্ষ ৰবীন্দ্ৰ নামজাৰি নাই মেপত উক্ত দাগৰ কোনো ৰাস্তা অংকন নাই কিন্তু মহামান্য আদালতৰ হুকুম মতে 572 নং দাগৰ পূব সীমাৰ পৰা 23 ফুট এৰি 10 ফিট বহল 10 ফুট বহল আৰু 80 ফুট দীঘলৰ ৰাস্তা এটি গোচৰৰ দুয়োপক্ষৰ সন্মুখত জোখমাখ কৰি মুকলাই দিয়া হ'ব মুকলাই দিয়া ৰাস্তাটো ট্ৰেছ পেপত চিহ্নিত কৰি সংলগ্ন কৰা হ'ল well meaning there by my lord this road that has been cleared at page 33 is the sketch map of this IA, this road that has been cleared as per this report, while submitting report, they have said that we have complied with the injunction order, but they left 23 feet to create a 10 feet road. This stripe is 10 feet only. So they have not cleared this footpath, as per that report. Now a projection is tried to be made, the road has been cleared, thereafter construction, and that is not so, my lord. As per earlier report in 2018, in presence of all, Circle Officer created a road in the middle of the Doug number 572, not this Sidul B. Very clear, my lord. Page number 73, if your lordship takes up again, along with page number 33. 73 and 92, right. কিন্তু মহামান্য আদালতৰ হুকুম মৰ্মে উক্ত 572 দাগৰ পূব সীমাৰ পৰা 23 ফুট এৰি 10 ফুট বহল আৰু 80 ফুট বহলৰ ৰাস্তা এটি গোচৰৰ দুয়োপক্ষৰ সন্মুখত জোখমাখ কৰি মুকলাই দিয়া হ'ব মুকলাই দিয়া ৰাস্তাটো ট্ৰেছ মেপত চিহ্নিত কৰি সংলগ্ন কৰা হ'ল This is the report of Circle Officer which has been enclosed with that report at page 70. If now, my lord, from page 70 we say, my lord, rather, that road has been cleared, should pass, then again it is blocked. This will probably not clear, my lord. Because what was cleared, that is after leaving 23 feet, another road. It's a different road. And trace map is there, my lord. That trace map they have placed now. Now in the trace map, your lordship will see, if I am permitted to place, I don't know whether it is there. Lordship will see in the middle of Doug number 572, there is a road they have drawn. And we have challenged that also before the Circle Officer. Without paying us compensation, how can you draw a road in our Patta land? That is a different issue, my lord. But if we project this, my lord, the road has been cleared in 2018, then this violation, because what we admitted when the status quo was lifted, then there was construction in 2016.
Okay.
Now, my lord, projecting this says that after 2018 we have constructed, not so, my lord. My lord, tin barricade, they say, tin barricade, this report also said, there is a concrete down up to 3-4 feet, it's a concrete wall. Thereafter, they have raised, obstructed by tin. That is the report. Well, tin house is not there. My house may be protected, my lord.
Okay, I will check. Sir, Sarma learned for the petitioner and Mr. S. Dr. learned City Council.
I'm obliged, my lord.
Mr. Clio learned argument concluded, order rejected.
I'm obliged.
Yes.
This revision has been prepared in the order dated 9/11/2023, whereby the prayer of the petitioner regarding to compare of the photocopies with the original and to mark them as exhibits were denied. Now, the petitioner herein, he was the plaintiff, he filed a suit And along with the suit, my lord, some documents, photo state copies of some documents are where, my lord, also filed with the, my lord, petition claim. That is at page 27 million.
Hard to main kotha
No, it is.
already hard in length pilot earlier.
My prayer was that, my lord, since it was considered by this honorable court on by that, my lord, learned trial court, that is lordship may kindly page, my lord, 37. It was the first petition, my lord. 1/22/12/22. Photocopies of certain documents along with the affidavit as exhibits, and the plaintiff prayed before your honor to allow him to prove the cross examination also at the time of marking exhibits. But on that date, my lord, the court was on leave. The court was not there, my lord, so it was not considered. Then, my lord, second, my lord, petition was filed on, my lord, 11/4/2023, page 41. With the same period, my lord. That the plaintiff stated that he submitted some photocopies of the documents along with the affidavit, and the plaintiff prayed before your honor to allow him to compare those photostat copies with the original to mark exhibits. Then, my lord, it was allowed. Then page, my lord, 44. Both sides are presented. I have seen petitioner so and so file on behalf of the plaintiff praying to allow them to compare the photocopies of the documents submitted along with the PW exhibits with the original and to mark them as exhibits, considering the same prayer is allowed. Subsequently, my lord, he again filed an application, my lord. One, my lord, that is, my lord, page 41 was there. Then, my lord, again filed on, my lord, 17/5, page 46. Same period, my lord. But before, my lord, 17/5/2023, cross examination was done on 16/5. Then when this matter comes, then the defendants file an objection that you cannot file that petition because the cross examination already done. So new documents cannot be submitted after cross examination of the plaintiff. And that was filed on 18/5/2023, page 50. Page 50. Page 50. It is the petition of the defendants that the plaintiff has been cross-examined and he was crossed on the exhibited documents which were not in original, and the said facts were admitted by him in cross. Subsequently, an application was filed after cross to prove the documents in original which were not on record at the time of cross. And on this I also filed an objection. Then it was considered. Then the impugned order was passed. That is on 9/11/2023, page 59. After discussion, my lord, I am not going to read all the orders, my lord. The lordship may kindly turn to page 61, the operative part. My lord, last paragraph, my lord. In the present case, by the counsel of the plaintiff's own admission, he had filed petition number so and so to mark the originals of the photocopies of the documents listed as exhibits in the evidence on affidavit of PW1 after the cross examination of the PW had already been completed, and he was discharged and without showing sufficient grounds for the failure to produce them at the appropriate stage. As the cross examination of PW1 was recorded by Advocate Commissioner Anupama Borua and the necessary order dated so and so was typed later, this court had been unaware of the fact that the said petition had been filed subsequent to discharge of PW1 and had allowed the period of the plaintiff bona fide. The comparing and marking of the original documents as exhibits were completely beyond procedure, as the same was done behind the back. It is not correct.
Behind the back, yes.
Because it was earlier, it was admitted. It was as per order dated 11/5/2023. I have already seen page 44. The period was made on 11/4/2023. That is page 41 and except E, and the order at page F, page 44. Period was allowed. So it was not done behind the back. Due to some inadvertent mistake, that was subsequently filed, and then this order has been come. So it is not correct. After the discharge of the, my lord, the procedure as the same was done behind the back of the defendant and after the discharge of the witnesses, and as such, the same can be accepted, cannot be accepted. In light of the above observation, order dated 17/5/2023 is hereby modified to such extent in as much as petition number 662/23 is rejected. That is the second petition. My first petition is there.
Third, first, second, third.
Second petition, that is page 41 is already there, and the order was passed on on the same date, 11/4/2023, page 44. It was there, but second on 17/5/2023, it was the third petition, page 46, that was rejected. So my lordship, for the ends of justice, that can be done, because I have on the last occasion, I create upon the judgment of this court,
Is judgment to happen?
it is 2009 on GLT.
2009.
Paragraph 12 is important.
Number, number, sign number.
I will go through the all the paragraph 12 operative part.
Yes.
Reading the provisions of Order 7, Rule 14, Rule 17, and Order 13, Rule 1, after amendment, it therefore transpires that the court can accept the documents filed by the plaintiff and receive the same in evidence on his behalf at the hearing of the suit, even if such document, though, ought to be produced in court by the plaintiff when the plaint was presented, or ought to be entered in the list to be added or annexed to the plaint, but has not been produced or entered accordingly, provided, of course, with the leave of the court. Such discretion of granting or refusing leave to be exercised by the court as noticed above must be based on some foundation and cannot be arbitrarily exercised. Such discretion has to be exercised judiciously and keeping in view the fact and circumstances of his case and also to do justice between the parties. Therefore, it is not that no document after settlement of the issue can be accepted by the court at all, copy of which was not filed along with the plaint, though required to be filed. The plaintiff, however, in order to make out a case for exercising the discretion in his favor, has to demonstrate the factual foundation to the satisfaction of the court relating to the good and sufficient reason. Furthermore, the court is in a given case can, in exercise of the power under section 151 of the CPC, accept such document at a later stage of the proceeding if making of such an order is necessary for the ends of justice or to prevent abuse of the position of the court. So my humble submission before lordship, without my comparing the original documents, I have no case. But since the trial court was earlier accepted, my allowed my prayer, but due to my inadvertent mistake, the second subsequent petition was filed and it was objected and it was subsequently rejected my prayer. So my for the ends of justice, lordship can consider that my documents can be accepted.
May please, your lordship. That matter is something different, my lord. Third petition, my lord, he says second petition at page 41, my lord. After page 41, there is order. After page 41, my lord, the first petition, no? Second petition. 11/4, after first petition, court was transferred, presiding officer was transferred. The second petition made on 11/4/23, page 41. After that, my lord, the order passed, my lord, on that day, 11/4, prayer is allowed. Although the prayer is, mayor allowing the prayer is not enough unless it is produced before the court and proved with origin and stamped it. They are not done so. That's why, my lord, in third petition filed on page 46, my lord, page 46. Again, my lord, on that the next date. Next date, my lord, next date was fixed on demand. On 17/5/23, they filed petition. And what order has been passed on 17/5/23, your lordship may kindly came to page 48. Both sides are represented. Page 48. P.W. Degendaka is cross-examined and discharged. P.W. Maheshwar Deka was also present. I have seen the report of Advocate Commissioner regarding completion of cross-examination of PW1. However, the report does not state the reason why the cross-examination of PW2 who was present could not be conducted today. The plaintiff had petition number 662/293 has prayed to be allowed to compare the photocopies of the document submitted along with the PW affidavit with the original and to mark them and exhibit. Considering the same, prayer is allowed, keep the original document tagged with chair. On that day, that was tagged, my lord, with chair, and on the in the meantime, my lord, in the above, because the commissioner has taken the, my lord, cross-examination. After taking the cross, it was placed before the learned presiding officer and presiding officer on that day. Thereafter, my lord, already, my lord, that cross-examination part is over, and thereafter, objection filed in by page 15, my lord. Page 15, objection filed by the defendant. On next day, when came to know, my lord, on 17/5, next day, the above defendant begged to submit as follows. The plaintiff has been cross-examined and he has crossed on the exhibit document which were not in original, and the said fact were admitted by him in cross subsequently. An application was filed by the cross to prove the document in origin which have not been recorded at the time of the said documents cannot be accepted the honorable court as the said original were not filed earlier to the cross-examination. What a cross-examination? My difficulties is, my lord, the cross-examination. What cross has been completed? What has asked by the cross, my lord? Page 4 of the cross-examination. Because it is amount to recall the evidence under order 40 under 18 rule 17. It's amount to, if it is allowed, my lord. I am going to page 4 of the cross. Moi adalotot evidence affidavit dakhil diso.
It's necessary to go to the cross-examination.
My lord. Because my cross-examination is.
You are only testing the order. Correct?
No, not that. If, my lord, that was allowed, what happened? Moi hopot namar logot exhibit 1 to 5 heibor xerox copy hoy. Original bor dia nai. To that extent, my lord, cross is over. Once, my lord, this secondary evidence is, my lord, produced with the evidence, my lord, and that is when the cross-examined, he admitted it, and thereafter, they just to fill up the lacuna, they filed this application to prove it origin, my lord. I am, my lord.
The application was filed and trial was session.
My lord, kindly pay what?
No, it's not go to the cross-examination.
My lord.
We are only testing the order.
Trial court impugn order. What is impugn order? Say thereafter recalls to some extent. What recall, my lord? You kindly come to page 61, my lord, 63, my lord, 62, last page, my lord. He is allowed to continue only in case of the cross-examination and examination in chief of PW1 shall not, my lord, disturb. Page 62. The comparing and marking of the original document and exhibit were completely beyond procedure as the same done behind the back of the defendant and after the discharge of witness Devendeka, and as such the same cannot be accepted. In the light of the above circumstances, order dated 17/5/23 is hereby modified to such extent inasmuch as petition number 662/23 is rejected and marking of the original documents as exhibit on 17/5/23 cannot be considered with respect to evidence standard in on behalf of PW1. Only on behalf of PW1 that was, my lord, kept intact. And next date, my lord, the suit shall therefore revert back to the stage of cross-examination. If your lordship, as well as 3 petitions has they made, nothing, my lord, there is any whisper that they have shown good reason that they have, why they have, it is submitted lately. In that aspect, my lord, the Supreme Court is, my lord, page 27, my lord, 1977 1 SCC 669, page 27, my lord, I am reading. Page 27, my lord, I am mark it. Para 27, my lord.
Yeah.
The High Court then seems to have vehemently criticized the manner in which Nokul versus Exhibit so and so were brought to the record at the late stage in breach of the provision of Order 13, Rule 2 of the Code of Civil Procedure. Here also the High Court appears to have misdirect itself by the completely overlooking the date and manner of which Nokul Beihas were produced by the plaintiff. As mentioned in earlier 13 documents of the plaintiff along with the written statement giving better particular August Dimaniman, the court applied its mind to the written statement and the documents and condoned the delay by express order. The court further directed the defendant to record the admission of denial of those documents. Last line is important, my lord. All this was done even before the evidence had started, and in this circumstance, it cannot be said that defendants were taken by surprise or they suffered by prejudice or by the production of those documents by an order that is so and so, so and so. Next, my lord. This provision clearly clothed the court with direction to allow production of document if it is satisfied that good cause is shown to its satisfaction. So my only point, my lord, here, whether there is cause shown, why they could not file earlier. And my lord, the similar in our similar, my lord, in the Delhi High Court, there are 10, my lord, say.
How prejudice would be caused to you?
Prejudice because, my lord, suppose so my case is, my lord, if they could not produce the original one, they could have taken permission to submit secondary evidence, but that has not been done.
The original copies were with them. Inadvertently, they could not produce it at the time.
My cross-examination, because
No, you tell me how prejudice is caused to you.
yes, my lord, cross-examination part, my lord,
Yeah.
will have no meaning for me because I could not have put that question if they could not have, didn't have, my lord, submit the original.
If you are
They have
allowed to
original.
cross-examine again, then
That is different thing, my lord, because they now they can already, my lord, they fill up the lacuna. There's nothing. There will be nothing, my lord, then. And my lord, in the same case, my lord, my only submission, the court has power.
No.
Court has power, my lord, to.
No, you tell me whether he is not entitled to fair opportunity to establish.
Yes, my lord. That itself clear, my lord. Law itself clear, my lord. Order, my lord. Order 13, Rule 1 itself clear. They can do. But, my lord, original document to be produced at or before the settlement of issue. Even if not, court can, with leave of the court they can, but there should be a reason.
Okay.
And to that effect, my lord, I am giving that Second one, my lord, para.
No, Mr. Kusami, there are multiple of bases.
Multiple,
Necessary to
multiple,
refer
yes,
also bases.
yes, my lord.
Third mistake I have done for the argument concluded already.
Item 18 and 19, both are analogous. And in the light of the decision of this honorable court, these two petitions to be disposed of. Paragraph 5 of
In the first item, it's order dated 18/8/2022, is the interim order.
Yes, madam. Same has been set aside by this honorable court earlier. That is your lordship's order has been placed on that one.
That page number.
No, I have placed the order. In the light of this order, these two petitions may kindly be disposed. Similar input order has been set aside by your lordship. Paragraph 5, my lord. Yes. Five.
Yeah.
Yes. May I please go ahead, sir? In the light of this matter, they filed an application under order 41 rule 27 for reducing evidence in the appeal stage. That is to be heard at the time of final hearing of the appeal. I think the judgment should lie. In that way, it can be disposed of. Only at the appeal stage.
Matter.
Yes, both
The petition.
Yes, both them.
There are 4 revision petitions. All are analogous, challenging the same order of the learned civil judge of Kamrup, Amingaon. 2 has been already set aside. 2 are before your lordship today. That is also reflected in the cause list also.
Okay, 18 and 19 will pass the order.
That is reflected cause list also. The analogous matter.
18 and 19 and
Analogous matter and other disposed of matters are also identical, which has been reflected in the cause list also.
Item 20.
Obliged.
Well, the matter has been listed by order, and perhaps they would like to press the prayer for interim.
Because my lord, writ has been issued in the execution case. I
Yes,
have placed.
the next date is fixed on 28th. So I pray that little accommodation if you lordship, my lord.
Then my lord, they will not proceed with the execution.
No, my lord, its next date is on 20th. So
But writ
lordship,
has been issued, my lord. I am giving the order.
my lord, the matter may be fixed on 18th. My lord, we can.
In the meantime, writ, if it is executed, my lord, then your lordship will.
No, that is, but this urgency is not there. My lord, this by the similar method, my lord, by order, the matter was listed before the vacation court without our information. And while the my lord matter was pressed for interim order, the court was of the my lord view of dismissal of the petition. They have taken time. It was again listed on 18/7. That day also they have taken time, my lord, saying that senior counsel will be engaged.
Today has been mixed, my lord, without our information, not by order it has come. I am just seeking for little accommodation, my lord, maybe take it over.
One thing, your lordship may understood one thing. Suit was there.
Yeah, you complete.
Lordship. So therefore, my lord, they are, my lord, having urgency because my lord, the execution case is there, writ has also been issued, but next date is fixed on 18th. And no. My lord, writ has not been issued so far as my lord, my friend is saying, my lord. But rather, my lord, they have to, my lord, submit the progress of this court. This is the order of the, my lord, executing court. My lord, this may not be on record, no, it is on
The order has been-
10/7/25.
I have given the order, one order before. your lordship.
10/7/25.
Decree holder is represented in 1/7/25, PO is on EL, fixed 10/7/25 for necessary order.
Yes, and 10/7 order is here. And so, my lord, expressing urgency, my lord, matter was listed in the, before the vacation court. My lord, court, my lord, during, my lord, hearing, court wanted to, my lord, saying that there was no case. Adjournment was made, matter was fixed on 18/7. Then by themselves, they had taken time.
My lord, 18/7,
Now-
my friend is saying it was not, it did not reach, my lord.
Let him complete.
Now today again by order without informing us, my lord, suddenly my lord, the matter has come, it will require some length of hearing, my lord. So therefore I'm asking a little accommodation only, my lord, the days, my lord, first August, my lord, event.
That is fixed on 28/8/25 for hearing on the petition.
208.
This August. Or it can be taken up even 8, my lord, 8 August. My lord. 8 August.
Yeah, 8 ago.
No.
Or, so, today, it would take, yeah. Or that concept of complete, that's the one, the book, or that. That's what. That's not. Take care, or that. I suppose the matter on 8 of August.
8.
My lord, can our observation, my lord, interim order will be considered at that
No,
day?
this was not considered on the earlier 2 occasions also.
My lord, if I can place it before your lordship, on the ground of that agreement has terminated tenancy.
We'll consider on that.
Okay.
May I please, your lordship?
Yeah.
Lordship, first thing is that my name is not been appearing in the cause list actually, I.S. Majumdar. And Ali name is there, he's my junior. So that I would like to state, first of all. Second thing is that I could, before I go for this one, some facts has to be known to the court actually. In 2020, after a quarrel, my wife left my house and she took my daughter also with her to her hometown, Nalbari. So since Corona was at that time, it was okay, fine. But after Corona, she came to Guwahati and she was working over here. Right now also, my daughter is left at Nalbari. For that purpose, I had filed a misguardianship case 75/2023 as a visiting right. Visiting rights means the WhatsApp call, phone calls. I can go and pick her up. That's the thing. At that time, she was of age of 6 years. Now she is of 11 years. Now the impugned order which the family court has given is in page number 17. May I please? 17 actually, if we come to the point number 5. Upon hearing the petition and the respondent, it is held that the respondent shall produce Miss Isita Deka in the court on the day of her appearance in the cases pending within the sizes. And the petitioner can meet Isika Deka in the court premises on that day. Actually, there are some divorce cases is also going on maintenance process. Now the thing is that what I
said to this court actually, the day when this court cases are going on, it's not an off day for her. She has got schools also. And by bringing her to the court, the environment and the condition is not as of like that, the father will meet their daughter. So our humble prayer is that this order may be set aside and I may be given the liberty to visit my daughter and to have a talk over her.
Okay, let notice go at this instance.
Oblige.
We admit you subject.
Yeah, actually okay, Your Lordship, I will.
Or, sir, I asked Mr. Lorette, the subject under section 22 directed against the order dated 7/9/2024 caused by the learned principal of the transport for in Miss Vacancy case number 75 of 2020 in MC civil number 67 of 2020. Wherein repeated visiting right was allowed to allowed to the appellant, which is only minor than the whereas the memo of evidence and the ground there and the first side order dated 7/9/2024. That made it to notice the response later that for to be taken by a registered post alien on the way the this subject for it.
Your Honor, can I pray for a fixed date, any date of your choice? Any date, fixed date. Can I take a date, Your Honor? Obliged.
My Lord, appeal on the order 43 rule 1R. My Lordship will find the impugn order at page 61. Operative portion, your Lordship will find at page 64, paragraph 7. My Lord, if your Lordship is true, my Lord will kindly come to page 33. This is the document number 3 in the suit, my Lord. Page 33. Pursuant to this power of attorney, I am running the wine shop since the year 2020. And there are documents, my Lord, to substantiate, my Lord, that I am running the same. And there later on, my Lord, on agreement. There was an agreement between the appellant and the respondent number 1, my Lord, 28/9/2024, whereby the respondent number 1 agreed to insert me as a licensee in the license, my Lord. And the said agreement was notarized on 26th of May 2025. And as an advance amount for the month of June, a sum of rupees 38,000 was also accepted. Thereafter, my Lord, when I insisted for money receipt for the month of June 2025, the respondent refused. On inquiry, I have come to know that, my Lord, he is contemplating to let the shop to the respondent number 2. So I filed the civil suit with an interim prayer, my Lord, which your Lordship will find at page 58 of my injunction petition.
What is wrong with this order?
My lord, as on this date, my lord, I have a stock of 9,90,950 rupees liquor. Plus I owe 18 lakhs to the bonded warehouse. Now, if I am thrown out of the wine shop, which is my sole source of income, I will not be able to pay the money, neither, and then secondly, the money invested will go. Hello, the respondent number 2, one is trying to insert the respondent number 2 in the license by entering into a lease. Now, if that is allowed, my lord, I will have no case, my lord, and I will be out of the shop. You know, these incidents were happening since 2016, my lord. I have made a statement, my lord, to that effect. Page 22.
So if there is an observation of the learned trial court in paragraph number 7.
Yes, my lord. She is saying, I have not claimed pursuant to special power of attorney. She is saying, I have claimed pursuant to the agreement which I could not produce because it's not in my possession. I have a prima facie case to go for trial, my lord. He will produce the document under section 65 of the Evidence Act. Now, so far it relates to continuation of my shop.
Whether in the plaintiff you have made any such agreement that the original document is
Yes, my lord, I have made a statement.
where?
My lord will kindly come to page 22. I have quoted what was the terms and conditions. Page 22, besides other terms as detained in the partnership. So it is also pertinent to mention here that the aforesaid deed is in possession of the defendant number 1. And as such, the plaintiff prays before this honorable court to direct the defendant number 1 to produce the same before this honorable court. At this stage, if your lordship will not protect me, I will go out of the shop, firstly, which is my sole source of income. Secondly, my lord, I will not be able to repay the amount. And I have made a categorical statement. Your lordship will kindly come to page 23, paragraph 10, my lord. You know, what happens here is, my lord, the licensee who cannot run enters into an agreement with the financial sound person. And then when the shop starts running, they become dizzy and they start acting like this and they illegally locks the shop. Thereby the financial partner, whoever supports, gets lost, my lord. My lord, I have made a statement. It is also page 23, paragraph 10. Since the year 2016, there are a number of instances where the licenses of an excise shop had thrown out the partner of the license without following the due process of law, either by using force or by using woman card. There are civil suits pending between the licensee and the aggrieved partner before this honorable court. I am talking about the trial court, my lord. It is respectfully stated that in all those cases, the licensee invoked partners due to financial crisis. And when the said wine shop starts flourishing business in the hands of the invoked partner, the licensee illegally throws. And here, same movement is going on, my lord. That is the reason I approached trial court. And the trial court refused to grant me injunction. Now I am before your lordship.
Oh, you told me how this impugn order suffers from any illegal.
My lord, the impure order, your lordship will kindly see. What is the finding at paragraph 7? The main suit and the injunction application have been filed by the petitioner not on the strength of this special power of attorney. Well, special power of attorney comes because I am claiming that I am running the shop since last 5 years, pursuant to the special power of attorney. And now, after having a good relation with the licensee, I have entered into a business. I have filed the suit for specific performance of contract. Now he is not giving me the partnership agreement, and on the contrary, he is trying to throw me out, my lord. When the business flourishes, my lord, everybody jumps, my lord, like this, my lord. In fact, it all started, my lord, since 11/7/2005. Your lordship will kindly come to page 30. Here, initially, there was a partnership agreement between the licensee, the respondent number 1, and the pro forma defendant. Page 30, document 1.
Office to appeal system. Will you fix it sorted? You will serve notice by Thursday.
My lord,
There will be some third paper.
my lord.
Sir, that's running. Okay. Third. Third. Order for 1 hour. Order dated 6. Six. 5. Part of memo by admit notice to the response. Return every month. Can it be on
11th of my lord?
August?
My lord.
Step ticket by register. ATM by the process. Days from today. 2 working days from today. Justice service also permitted. After that service of
Asking my registered post for you. My lord, can it be registered post?
Yes.
Because he has got no good
Yes.
relation with me, I believe, right now.
in addition to that registered post, this justice service.
My lord.
Perfect.
My lord, may I, till then, my lord, position as on today, till 11, my lord. Because if I am thrown out, my lord, what will be the purpose of coming here, my lord? Again at 11, my lord. Till then, my lord, today is first, my lord, 10 days, my lord.
You serve notice, we will say.
My lord, I'll take steps today, my lord. I'll take steps today, my lord.
On 11th, we will consider the same.
My lord, till then, my lord, 10 days, my lord. Well, if I take steps, everything will be all right, my lord. But on 11, if I am out of the shop, my lord,
No.
I will not be able to restore my position. I have to again file another suit, my lord, for restoration of position. Well, for 10 days, my lord.
No.
Well, at least status quo as on today.
So we have to pick the prima facie. So you have demonstrated a irreparable loss of the.
My lord, irreparable loss is, my lord, my 29 lakhs rupees stock is, I
No,
owe.
that is there, but prima facie is we have to see. Yes, next item.
This is an appeal under order, my lord, the 43 rule 1 R, my lord, of CPC, my lord. Against the order of my lord, against the order of my lord, learned senior division, my lord, Morigaon, my lord, civil justice senior division, Morigaon, my lord, whereby the prayer of the appellants, my lord, for ex parte injunction was not granted, was not considered. My lord, petitioners, appellants, my lord,
No, where is the appeal order?
my lord, last page, my lord. Page 126, my lord, last page. By this order, my lord, the learned Civil Judge Senior Division only, my lord, issued notice. My prayer was, my lord, our prayer was, my lord, for ex parte injunction. That was not considered, my lord. What is the, in this case, my lord, it is prima facie case on behalf of the, my lord, in favor of the, my lord, appellants, balance of convenience, also in their favor, my lord.
Interim order is that page, sorry, the impugn order is that page number
126, my lord.
146.
26, my last page, my lord.
But whether notice was issued at that.
Yes, my lord, but
By that
expert,
order where?
page 126, my lord.
Yes.
This is petition under order 39, rule 1 to 1, 2, and read with section 151 of CPC, my lord, by filed by appellants for temporary injunction against the opposite party number 1 to 5. It is checked and registered as a missed case number 36, fixing 1/8/25. My lord, without considering the prayer, my lord, prayer for, my lord, expert injunction, my lord.
The trial court has fixed the matter today.
Yes, my lord, today it is been.
What happened today?
Nothing has been done, my lord. They have not appeared. The respondents have
You
not.
produced that order?
My lord,
You produced that order on Monday. The order passed by the learned trial court
yes, please.
has to be produced on Monday before this order.
My lord, Monday it will be some difficult, man, because certificate copy will not be available. Tomorrow is holiday, Sunday is holiday.
That Tuesday.
Yes, please.
Or it's a sober learned for the. It's under order. Prepared by the. Challenge take the correct. The order dated 5/7. Take it perfect. Fine. You get prepared. Yes, for 7. Care for grant of expert. That's made in the. That intake is for 36 of 25. Compared to 2, 1 and 2. We do 6. 1. There is the benefit and the cost. So, there is the order dated. I think. It's there is the Perusal of the impugn order dated 5/7/2025 indicates that the matter is listed to take that 1/8/2025 before the trial court. So service report that WO. Recording type is provided that the learned counsel for the appellant shall bring on records order dated 1/8/2025 passed by the learned trial court on Tuesday.
Obliged.
Fair will be considered on
24.
Thank you, sir. Lordship, this is an MNC appeal under section 173 of every act. And so this is for enhancement of the quantum. I beg your lordship indulgence to peruse the order dated At 14/5/2025, the case was taken up before this honorable court. An observation has been made that the key document, that is the exhibit number 4, hasn't been produced. So, and a direction has been given and to file an affidavit. And in compliance of this direction, we have filed an affidavit where the key document which has to be assessed is it has been filed here in regarding to the income of the deceased. Yeah, honorable lower court has done an error that entire estimation of the calculation has been done as a notional income, whereas the claimant used to, where the deceased was a earning member and he was the imam, and this exhibit number for my lordship may kindly peruse the exhibit number 4. He was an imam, he was an earning member. But what the honorable lower court has assessed evaluated the income as a notional income. But notional income actually is a very hypothetical, and whenever there is no any formal income is there, then notional income is taken into consideration. But in our
Receipt salary.
here's a received salary. Here that is exhibit. Here's a received salary from the mosque, and in that and PWD.
Whether you have produced those documents.
We have produced those documents and we have filed an affidavit. It is an exhibit 4.
Okay, then notice to it. Ordinance are arguably loaded on the it's appeal under 673 of the MDA. Directed against the judgment and award dated 29. MSC case number 55 of the 19. So when they heard it by judgment, the award dated so directed the respondent insurance company to pay a sum of rupees 8 lakh 8,000 with interest at the rate of 9% per annum, the rate of filing under to the appellant date. What is the memo of appellant account? And also what is the impugned judgment and award dated so admit this will not is the respondent for the ADN process. This is the call for the record alert and the better.
Please. Your Honor, we have already filed our affidavit in opposition, but it is not before your lordship. Your lordship may be pleased to fix up a date.
Yes, madam.
May I please your lordship, here for the petitioners, I'm for the petitioner wife. We challenge this impugned order is on page number 174, your lordship. Lordship, if I may in brief tell the case, we had filed this the opposite party have
Filed by him is not the record. Let us fix sorted.
Yes, your lordship.
So that they
Yes, yes. We last date there was an interim, but there's no fixed date for allowing the mother. I'm for the mother petitioner to allow the husband to speak to the eldest son. It's actually with regard to visitation rights to speak to the elder son over the phone because he's placed in Noida and we are in Guwahati and getting no visitation rights and we have no contact rights with the child. It's only when the father allows the mother can talk to the child. When the child comes to Guwahati, when the child is here in court, father will allow, he'll meet. They have 2 children, one is with her, one is with him. She came out of the house to visit her parents. After that, he's not allowing her to go back. He's filed several cases against her. So now, ultimately from Noida, it has been transferred to Guwahati and family court in Kamrup, and it's pending over here. But as for 18 months, my son was 6 when I left him. And for 18 months, I am not getting any, in contact as in meeting, seeing him in court. He comes over for half an hour. Court gave 1 day's time during some birthday. That was the only day. Court rejected my winter holidays petition. Again, it was rejected. The summer holidays petition also rejected. I'm the mother. Child is 6.5 years. For 18 months, I have not even had a proper conversation with my son. That is the case, your lordships. On the last date, Honorable Court had allowed us to, had directed the respondent to make sure that the phone calls are picked up. on the when she calls, because the child comes from school at 2:30, comes, the maid is there. The respondent goes to office, he comes only by 8:30. So when the maid is there, mother calls from here, the maid does not pick up the phone. They say, yes, he speaks, but that is when the father comes at 9 o'clock of the night, when the father feels like allowing the video calls. But that's not how it works with the mother, Your Lordship. So we are only asking for visitation rights, Your Lordship. We had asked, it was rejected. You're not allowing us to talk to the child. 18 months, Your Lordship. Now the child doesn't even look at me when he comes here.
Madam, how will you consider it?
Yes, Your Lordship. Yes, Your Lordship.
Or that for what? Or that-
Each of three.
also the learning of the response of that despite the video cases. By some record. That is, by some, there is the method of
19th Paribo, 19th August, 19th August, 19th, 18th or tax fix আছে 19th, 20th no করো please.
19.
Obliged. Obliged.
Petition on Wait, please, your lord. My lord, we have come against an order which is passed by the Learned Trial Court allowing the amendment application without hearing us. That's at page 74, my lord. 74. 22/7/2022, my lord. Lordship 74.
Got it.
Yes, may I read, my lord? This petition, I intend to dispose of so and so. Both parties are represented, all already heard, both learned counsel. I intend to dispose of the miscase so and so. Orders, learned counsel defendant in the usual fairness would concede the prayer. To my instruction that there is no, that we have conceded the prayer because apparently it appears this order is 22/7/2022. If your lordship looks into the next page, an application was filed at page 75 on 4/6/2022. And this application was filed under section 30 of the CPC with a prayer for summoning the marriage officer to submit a report. Kindly see whether any marriage between the petitioner and respondent was registered under the provision of the Special Marriage Act and to produce marriage certificate if any. So this is when it was spent, this 4/6/2022. Why we filed this application? My lord will kindly see the suit which was filed. At page 20, my lord, the suit was filed. Kindly see at page 20. It was an application for resolution of marriage. If your lordship will kindly see at page 20, title suit, an application for resolution of marriage under section 27 of the Special Marriage Act or any other appropriate Hindu family laws. So it was registered under 27 of the Special Marriage Act. And if your lordship looks into it at page 23, if your lordship see at para 13, that the cause of action for the petitioner at page 23, mine, at paragraph 13, that the causes of action for the petitioner under 27 of the Special Marriage Act arose at Jorat under jurisdiction of this honorable court on and from 31/1/2008, date of solemnization of marriage, on and from various dates when the petitioner is subject to mental and physical harassment by the respondent, on and from 16/8/2013 when the petitioner alone compelled to leave the society. So entire suit was structured on the basis of 27 of the Special Marriage Act. And they wanted a decree of divorce under the Special Marriage Act, under 27 of the Special Marriage Act. Now we file a written statement at page 26.
And our specific stand was that there is no special marriage which has taken place under the Special Marriage Act at para 6. Kindly see, my lord, para 6. Kindly see para 6. He admits that his marriage with the solemnized according. However, the respondent denied the statement of petition. Thereafter, his marriage was registered with the petition before the marriage officer. The respondent begs to say marriage with the petition never registered before the marriage officer or any other place, and as such the petitioner is put to strictest push for a statement. Further, respondent gave to next so and so enter into marriage by fraud that at the time of entering marriage, respondent petitioner suppressed about her earlier marriage. There was a marriage which has taken place earlier, her marriage, and that was suppressed. Now, my lord, this is basic stand we have taken. The issues were framed. 5 witnesses were examined. Now, while examining the petitioner, my lord will kindly see in her cross-examination. If your lordship kindly look into the cross-examination and what led to file the application for amendment, my lord will kindly see her 59. At page 59. Kindly see page 59. I have not furnished any document with regard to the registration of my marriage with respondent, my son's date of birth. This is my second marriage. Before marriage with respondent, I was previously married. There is no mention of my first marriage in my plan, as well as my evidence on affidavit. I have not furnished any document in respect of my divorce from my first husband. Now, this is what the statement, the cross-examination, my lord, of the petitioner, of my wife. And my lord, immediately when we filed an application for calling of the marriage officer, now immediately she filed an application for amendment. If your lordship kindly see the amendment application which has been filed is at page 66. If your lordship kindly see 66, there is only 4 paragraphs which has been mentioned. He wants, my lord, he wants the dissolution of marriage under so and so cost title to be changed. And at page, next page 67, that the petitioner respectfully stated that the statement pleads are objected by defendant. Lordship got it, my lord? Objected by the defendant response, and this honorable court suggested to amend the pleading. The court has suggested to amend the pleading because as there is an objection made by the defendant, by us, that how it can be, and the court said the suggestion was given to amend the pleading. Now, I think on the last occasion, there is a question which was put to my learned friend. I was not present, that how it materially affects him. If this is being not allowed, an amendment is allowed, and there is no chance given to you to file an objection. Because normally in the trial court, my lord, when an amendment application is filed, always a chance is given, or otherwise we concede that amendment may be allowed. But your lord.
Mr. Das, you see, going by the impugn order.
Yes.
Can it be said that you have not been given the opportunity?
Yes, my lord will kindly see. 73 kindly see. This is a main suit. Kindly see the main suit.
Come to the impugn order.
No, I am coming because on 22/7, on the same date, kindly see, my lord, none represented. On 22/7 at page 73. None represented is a main suit. Registered so and so, fixed for petition, evidence so and so. And if your lordship kindly see in the main media case, both parties are represented. What respectful submission is that if none represented in the main suit, normally main suit is fixed with the miss case. Now, miss case, if that be the case.
Maybe on that day, this case was listed.
No, I'll tell your lordship what is there. This is a case where amendment application is filed always a chance is given to file. Now materially how it affects, I'll tell your lordship.
No, that's all right. If you are disputing this proposition in the order,
Yes.
then we have to call for the record. We have.
Yes,
to
your
make
lordship
whether-
will call for the record. No, what I said, that your lordship has asked a question, a very pertinent question, how materially it affects. If it is under 27 and it is under section 13 of the Hindu Marriage Act. Because if suppose, let us say that I don't object and say 13 of the Hindu Marriage Act, because their structure of the entire case was 27. Now, if your lordship looks under the Hindu Marriage Act and 27 of the Special Marriage Act, there is a slight difference is there. Under the Hindu Marriage Act, if your lordship sees section 5, dissolution will take place only condition section 5 of the Hindu Marriage Act, read be section 7 is being followed. Then the question of dissolution of marriage will take place. But under the Special Marriage Act, under 27, it is a marriage which is taken place and it is registered. So this is an important, that's why the structure of the entire case, nature of the entire case will change. Suppose I file an objection, I get a time to file an objection there in the amendment application, and their whole structure of the case was 27, I would have objected before the learned trial court, and I have said that this I have an objection because entire nature and character under 27 will change with 13 of the Hindu Marriage Act. Because for Hindu Marriage Act, my lord, the condition of the marriage under section 5 and 7 is very important to establish. Then thereafter, dissolution of marriage. If there is no establishment, how a marriage has taken place, that is the reason why I want to address before your lordship. But your lordship wanted to call for the record, your lordship can call for the record. Absolutely no problem for me, my lord. Because your lordship was asking a very pertinent to my learned friend, how materially it will affect. That I think, if I'm not wrong, that is what your lordship has asked to my learned friend, and that was communicated to me.
Now you are disputing your presence before the learned trial.
Yes. Definitely your lordship will call for record, see the original record, what is there. But I found, my lord, the nature and character will get changed. Subject to what your lordship will decide. What is the object behind of the Special Marriage Act, and what is the object, legislative intent and object under the Hindu Marriage Act? 13.
Object in both the legislation is same for
But
dissolution of
my
the
lord,
marriage.
my lord, but to establish, my lord, there are the Hindu Marriage Act, this Sopinda under the subtopoty, but that has to be rights, rituals, rights and rituals and not that is
That is there.
that is why I'm saying, my lord, entire nature. But your lordship wants to call for record, please call for record. I will address before the court how it changed the nature and character. Your lordship will call for record and see. I am denying it, my lord. Social rights, my lord, that will not do. They have stated in one paragraph in the amendment, social rights and rituals. That with greatest respect, I'll address before your lordship. That is not enough. Social rights and rituals. That I will address to your lordship, how the nature and character will get changed. Subject to your lordship will examine. Lordship will call for record and see that.
Yes, Mr. Purva. Let the
I
record come back.
am submitting answering one by one question to him. First,
Mr. Purva, today we are not hearing on the petition. Let the record come since he has disputed his presence before the trial.
Logic for my submission, they only to deciding this matter. If lordship is to think that is disbelieve the court order, that is the fine thing. Because of the fact that 3 orders have been annexed here, from the 72 to 74. Lordship will finally see 72. It is already hard the both sides. Lordship 72. Lordship page 72. Page 72. CR received miscase is so and so issued by file of pair of amendment of cost petition, cost title of petition. It is not the total pleading of pleadings. Cost title already hard both sides. Lordship will find and fix 27 for order. Matter was hard and it is fixed for order. And 73, that also reflected, and 74, the order has been passed, and the pass, at time of second opportunity is given to them. And their counsel say that is, he is considered to the pair. Now, there is, if they say that we have not said, or if they said that I was present, not present there, then what is the learned counsel who they must have come to affidavit, because this is wrong. And if they have right, immediately they should file a review petition there, because if that it is not there. And second thing, Lordship will find the section 27, Lordship will rightly said, and Hindu law and section 27 of special marriage and section 13 of the Hindu Marriage Act, absolutely same. I will sum. I will show Lordship. Section 27 is Special Marriage Act. Only the serial number is different. I read 1A of the 27 is similar to 13(1) of the Hindu Marriage Act. B is 1(3) of the. If you compare it to all the ground here, is the same ground is given at the section 13. And F is 5. I proceed fine. I compare with all this. The both are absolutely wording are same. Not only Lordship lightly said that it is the same. In the legislation brought this Special Marriage Act because of it, only because of the for the proving of a case, the intercaste marriage or where social marriage is not performed, social marriage is not performed, to protect that. Because Hindu Marriage Act itself, section 8, Lordship will find there is a provision in section 8 of Hindu Marriage Act, even solemnize the social, there is a provision of section 8, which if I am not that registration can be made. And here, the petitioner himself said, not denied the social marriage. And then what will be the difference? They did not deny the social marriage in the W.
Okay, let the record come then.
Because my problem is that for this reason, the whole suit is state.
We will fix a very short day.
Oh.
We will call for the record by special messenger.
But Lordship said that only for this ground, this petition, the whole proceeding has been stayed for a year, Lordship.
That's all right, we'll fix a very short day. Heard Mr. Details, learned Senior Counsel assisted by Mr. Talukdar, learned Counsel for Dr. and Mr. Borua for the response. After hearing learned advocates of both the parties, present of the record of the learned trial court is also necessary, and according to it provided that the call for the record of the learned trial court by special messenger 11.
Thank you. Can it be on 12, my lord?
My lord, may I please your lordship? My lord, this is a regular first appeal, my lord, under section 96, my lord. That is related to order 41. Against the, my lord, judgment and decree dated, my lord, 39/24, my lord, passed by the learned civil judge, Senior Division Dhubri. My lord, the suit was for specific performance of contract. Lordship, the judgment is my lord.
Heard Mr. Kesina, appeal under the appellant to challenge the order judgment that dictated 30th May 2024 on the in title number 12 of 12. This to be declared by judgment ordered civil the senior division yes, the plaintiff. There is a memo pending at the government hearing and also produce the judgment that dictated that made issue notice to the responsibility submitted by research to media. Resident will call for the report from the Lord and what I is there?
My lord, I is there. My lord, I was filed for under order 41 rule 5, my lord, for suspension of the judgment and decree. But my lord, in the meanwhile, they filed the execution proceeding, my lord.
When?
Lord, already in Dhubri, my lord, they filed in the month of May. Now, title execution number is, my lord, TX number 2/25. Pending before the, my lord, Lord Civil Just, Senior Division, Dhubri.
When the next date is fixed.
My lord, yesterday was the date.
But in your application, where you have mentioned about the execution.
No, my lord, when this first appeal was filed, my lord, in that time, my lord, that execution was not filed. This appeal was filed in the month of January, my lord. If
Notice go in the meantime, you what is the order passed by the learned executive court?
my
On next day, consider your fair
my lord.
list of properties.
Attend for hearing under order 41.
Obliged.
Number 27.
Lordship, this is the second appeal against the judgment of reversal by the learned civil judge, senior division, Charaidev at Sonari, Lordship. The petitioner here, appellant here has filed the title suit before Munsif Charaidev, which was decreed, and subsequently on filing appeal by the respondents, same was reversed. Lords, we have annexed the judgments. The impugned judgment is at from page 13 onward, Lordship. In the impugned judgment, Lordship, while deciding the issue number 2, at page 26, Lordship, landed first appellate court has decided the issue of maintainability on the question of limitation and adverse position that has never been pleaded by the defendants in their WS. No plea was taken regarding adverse position, plea of limitation, Lordship.
So now clearly because the plea of limitation was not taken in the WS, is the court not entitled to examine the same?
No, definitely, Lordship, but it was on the plea of adverse position. It is the adverse position that has, the defendant has become the adverse to the plaintiff. For it is well settled law, let's say, Lordship, that adverse position has to plead and prove. They have to take the plea. Mayor entering the name in the Jamabandi, which we have objected and then cancelled, that cannot be the starting point of the limitation. They have tried to enter their name in the year 2002, which we have objected, and accordingly, subsequently, that was cancelled. Still, our name exists in the Jamabandi Patta. The findings of the learned first appellate court is page 27 and 28, Lordship. Para 19. It is our case that they are the permissive occupiers. In their WS from page 81, Lordship, we have annexed the WS. Not a single word has been taken that adverse position, Lordship. Simply they have denied our title and claimed their position.
WS is that page number?
81 onward, Lordship.
No, this paragraph number 5, the suit is part by the law of limitation.
No, that plea has been taken, but adverse position has to be plead, Lordship. When adverse position starts, the date of starting point of the adverse position, they have not taken nowhere, no counterclaim, Lordship. Their only prayer is to dismiss this suit. The plea of limitation without anything, any detail, Lordship. No, even not a single word that 65 is applicable here. 64 is applicable here. Without anything in record, they have said that it was gifted to us by our mother. No gift deed, no evidence. We have proved the Jamabandi copy, we have proved the Mandal, records of rights have been proved in records in the court, trial court, Lordship. At page 63, Lordship, of the trial court judgment. In the present suit, the defendant did not dispute the Exhibit 1 Jamabandi as such and also failed to lead any evidence to show that mutation of the name of the plaintiff Exhibit 1 Jamabandi was not done properly. Originally, it was a annual patta land. In 1972, it was converted to Myadi patta, Lordship.
That observation in respect of the adverse position may not be correct, but the trial court has definitely held that it is barred by the law of limitation.
No, that 12 years starting point, that has to be calculated, Lordship, from when? I am relying on a judgment, Lordship, of the Honorable Guwahati High Court, Lordship. Mayor entering the name in the records of rights does not become the starting point of the limitation, Lordship. It is when they deny the title. It is para 14, Lordship. The time will begin to run from the date when there is some threat from the defendant on denial of the title. When we have filed the suit, they have denied our title. Before that, they have never denied our title.
So the trial court has stated that it starts from the year 2002 when the defendant tried to enter his name in the record of right.
Yes, Lordship. They have tried to enter, that is the first point, they have tried to enter. We have objected to the circle officers. Their name was cancelled. The first stage on knowing that yes, they have entered their name in the records of right. We have objected to the first step, authority, that is the circle officer. And accordingly, after hearing both the sides, same was cancelled. That attains finality, Lordship. They have never challenged that order before either any filing revenue appeal or board of revenue.
What wrong with the trial court in calculating the
The limitation point cannot be on that point, Lordship. Limitation when they have denied our title. According to us, they are the permissive occupiers. Their plea is that the land was gifted. Another plea was will. At page 61, Lordship. They failed to prove any documents. The trial court has considered rightly that the Municipal Court, but the learned first appellate court has come to wrong findings, Lordship, on the point of limitation, Lordship. Says Article 65, Lordship, first appellate court has mentioned about Article 65. It clearly states when the defendants raise the plea of adverse possession, then only Article 65 will apply. Start. Once mutation has been cancelled by the revenue officer, they have not challenged it. Neither before any revenue appeal.
The questions you have suggested here appear to be a question of fact.
No, Lordship, limitation point, Lordship. We have suggested page 10, Lordship.
Sitting in second appeal, this
Appellate first court is reversing the issue of maintainability against the plaintiff under Article 65. It is a pure question of law, Lordship. Article 65, starting point of limitation, is a pure question of law, Lordship. When it will start? Whether simply they are trying to entering their name or when they have denied our title. Article 64 definitely covers 12 years period, but 65 starts the limitation when they claim the range of adverse position.
You produce relevant decisions in respect of Article 65 to show that it is a pure question of law.
Because 65 starting point is only when the plea raised. In a WS, when they claim, yes, our limitation point is starting from this date. They were nowhere in their WS, no plea of adverse possession, no counterclaim.
Fix it on another day.
Lordship.
Cleared on 65.
Lordship.
That it is a pure question of law.
Lordship.
Or supported or not supported. Let's stop.
Date may kindly fix, Lordship.
For further consideration.
Lord, oblige, Lord.
Wait, please, your lordship. My lord, I have prepared substantial question of law in separate sheet, my lord. Right. It is a concurrent judgment, my lord. The appellant here was the defendant in the original title sheet.
Why you are submitting the substantial question of law separated?
My lord, on last
Sir,
occasion,
these are different.
subsequently I prepared, my lord, as because, my lord, in my memo of appeal, it is not properly.
Casted.
Yes, my lord. And on last occasion, my lord, on that count, on 3 occasions, case was listed, my lord. It is 4 time, my lord.
On one occasion, there was a prayer for adjournment on your part.
No, my lord, due to lack of time, my lord. Paucity of time, court was allowed to time to next time.
On 25/2025.
Initially, I was taken time, my lord.
Yes.
And subsequently, due to paucity of time, suit was for, my lord, claim rent and eviction from the rented house, rented room, wherein, my lord, in the plaint of the plaintiff here, the respondent,
The title suit was filed under which provision of law?
my lord, title suit was filed under order 7 rule 1, my lord, rule 3, my lord.
No. Under which act? Rent control act?
No mention, my lord. That was not mentioned, but it should be Rent Control Act, my lord. Assam.
No. If it is, it was filed under rent control act, definitely this second appeal will be not maintainable.
My lord, in the title shoot,
Only
no.
division petition will prefer. If you have to prefer.
My lord, it is the second appeal, my lord.
No. If it is under the rent control act,
My lord.
then the second appeal will not lie because there is bar in the act itself. Only revision will lie. Therefore, I am asking you under which provision of the act it was filed? Rent control act or any other act?
My lord,
You are
title.
not sure.
I am not sure, my lord.
You obtain instruction then.
As because
if it is under rent control act, cannot affect.
Yes, my lord. In the original shoot filed by the respondent, here claiming rent and eviction from the rented room, the present appellant.
Then definitely it may be under rent control act.
Should be, my lord.
So you obtain instruction then.
My lord.
Come prepared on that one. Or Mr. K.U. Ahmed.
My lord.
Please submit. For further hearing.
My lord.
29. May it please us. Lordship, in this particular case, the respondent has already, we are the tenant in respect of 15 deciles of land at Dhubri town. Lordship, the respondent herein as a plaintiff filed a suit for rejectment against us. Suit was dismissed by the trial court. Against that order, they preferred an appeal. Lordship will find at page Lordship, they have filed a title suit page 103. Type copy, Lordship, find at page 96 onward. Mohammad Basiran Nessa, page 96. Lordship, got it? Page 96. Okay, got it?
96, yes.
96. That is page 96. Title suit number 395 of 68. Type copy. Lordship will find
What is this, annexure to page number 26?
page number
35 of 87,
page number
26.
Lordship, that is the title suit filed by us because that suit has been filed by the appellant was a minor. He was not implicated as a minor without appointing any guardian. Suit has been filed and decree has been obtained. I have challenged the suit, challenging the decree obtained by them as a nullity because without implementing as a guardian, without implementing my guardian, suit has been decree has been obtained. And considering the fact that earlier they have filed a suit against my forefathers and suit has been dismissed by the trial court, and thereafter appeal has been filed. Appeal also, Lordship, they have withdrawn without any compromise petition. After that, they have filed a suit stating that in title appeal, our forefathers have made a compromise, and thereafter, Lordship, on the basis of compromise, we become a permissive position, where fathers become permissive position, and on the basis of permissive position, we should vacate the premises. That suit, they have obtained a decree. Against that decree, appeal was preferred by our the person who has affected. Appeal was
87.
Lordship. Dismiss. Thereafter, Lordship, because of minority, after attaining the majority, I have filed a suit challenging the decree obtained against us is a nullity. That is, Lordship, title suit numbers 100 of 35 of 87, 100 of 2000. To come to that effect, Lordship, I want to show the earlier suit filed by them. That is, Lordship, page 96.
That is the title code number 395 of
395 of 68. Lordship will find final order at page 102.
Yes.
I hold that the plaintiff failed to prove the case, hence they are not entitled for relief in this suit. On the contrary, defendant could prove their case. I therefore make the following orders. Suit is dismissed on contest without cost. Lordship, got it? Lordship, thereafter they have preferred appeal before the appellate court. Lordship will find the appellate court at page 121. They have filed a petition in the appellate court, title appeal number 36 of 75. Huh? Lordship, title appeal number 36 of 75, page 120.
What?
120, 120.
Yes.
They have stated it is humbly submitted the case has been settled between parties. So therefore pray that parties are not interested to proceed with the case. I therefore pray that appellant may be allowed to withdraw the case. This is the petition filed by them before the appellate court. Petition, original petition at page 121. Thereafter, the appellate court dismissed the suit on withdrawn. Page 123.
120.
121 is the original copy and type copy Lordship will find 119. Type copy is 119. Application number 246 has been seen. Case is dismissed on settlement. Lordship got it. Lordship, if a suit is dismissed on withdrawn and there is a compromise petition, there should be a petition for compromise. There is no compromise petition filed with the petition in the title appeal. They have filed this petition, they want to withdraw the case on the basis of compromise. That we want to vacate the premises after marriage of my daughter. That is on the basis of that they have filed a suit and suit has been decreed against our other. And that suit was decreed. And in the present suit, Lordship, which was under challenge, I have adduced evidence to prove my minority at the relevant time by producing the school certificate. And that school certificate has been, my name has been recorded as Shah, Shankar Shah, Saha. That's why that certificate was rejected by the Munsif, by the trial court. In the appeal, I have filed a petition under Order 41, Rule 27 to prove the school certificate by adducing additional evidence. Lordship will find at page 90. Page 90. Pre-petition has been filed. Page 90, 92 and 94. To give additional evidence to bring on record that the earlier suit filed by them was dismissed by the trial court, Lordship will find at page 90, para 4. Plaintiff and performer defendant 4 were the minors at the time of decree of title suit number 3587 did not know the facts that title suit number 395 its result despite of exercising due diligence and produced such evidence while the suit of title suit number 100 of 2000 was heard and decided. Plaintiff appellant came to know the fact that title suit number 395/68 in October 19 was immediately thereafter filed a petition for certified copies of the plain and WS of judgment of has been supplied on 5/11/19. Plaintiff of title suit number has specifically pleaded that decree obtained by the respondent in title suit number 35/87 is a fraudulent, void. As such, evidence of the decision of title suit number 395/68 is most important and vital, which need to be adduced in the present appeal by producing additional evidence. As such, unless the plaintiff appellant is allowed to adduce additional evidence, aforesaid point which is not within the knowledge of the despite of exercising due diligence, trial of the title suit number plaintiff will suffer irreparable loss. This is one point. Second petition, Lordship will find, page 92, I want to prove in my minority, page 92, Lordship. Para 4, Lordship. Appellants want to adduce additional evidence about the age, title, and other motive available with him, acceptable by law. Unless appellant is allowed to adduce additional evidence, then appellant shall suffer irreparable loss despite having strong ground to succeed. Because if all this petition has been dismissed by the trial court, Order 41, Rule 7. Against that order, petitioner has approached this honorable court, and this honorable court, 135, 125. Page 125 is the order. They are dismissing the petition under Order 41, Rule 27. Lordship, CRP number 175 of 2022. Lordship got it. This court has allowed the petition, and this court has said page 132, relevant portion.
Yes.
Taking into consideration the facts and circumstances of the case, order that a demand passed by the courts then vacated, and parties are directed to appear in the first appellate court on 26/10/2022. First appellate court shall decide the said appeal, taking into account the observation made herein above, without being influenced by order that demand and title appeal demand. This petition under Order 41 Rule 27 has been allowed. Three petition has been allowed. Now, appellate court again did not consider this is application and decided the case without proof of the minority of the petitioner. Petitioner want to prove that Saha and Shah is the same person. We want to bring on record the full record to produce a said certificate. that has been rejected by the appellate court again. And to bring on record by additional evidence that original suit filed by them was dismissed by the appellate court on withdrawn on the basis of compromise, and there was no compromise decree to that effect. But appellate court did not consider this matter. So we frame Lordship will find substantial question of law at page 20.
These questions are not incorporated in the memo of it.
It is important in memo again, page 20.
This 20 it is after the certificate.
Page 20, Lordship.
It is after the memo of appeal.
So it is in the memo of appeal, Lordship.
Where?
Page 20, Lordship.
Got it.
Page 20 of the appeal memo, Lordship.
Subsection 3, section 100. PPC. You see subsection 3 to section 100. Section 100.
Appeal shall be heard on the question of so formulated, and respondent shall at the hearing of the appeal be allowed to argue on the case does not involve any such question. It was filed along with the appeal.
Along with the appeal, but it is not part of the memo of appeal.
It is part of the memo of appeal.
No.
Okay. Page 21, Lordship. Page 20. The appeal memo.
Subsection 3 to section 100.
Lordship. Subsection 3 to section 100. If an appeal under this section, the memorandum of appeal shall be precisely state the substantial question of law involved in the appeal.
Where you have stated?
Page 100, Lordship. Page 20, Lordship.
Page 20
of the appeal memo.
after the certificate. Is it part of the memo of appeal? In the memo of appeal, where you have stated the substantial question of
Lordship.
you have to file amended memo of appeal. You have to state the substantial
Lordship.
question of law in your memo of appeal.
Lordship, if Lordship want that, Lordship, I will file. But only thing is, Lordship, we maintain this procedure, Lordship.
No.
But
We have not been admitting second.
no, understand,
appeal in
Lordship.
this
I
court.
understand, Lordship. Understand, Lordship.
And there is also one decision of the Supreme Court where it is stated that substantial question has to be mentioned in the memo of appeal.
I understand, Lordship, what I pointed out, Lordship. Before certificate, it should be mentioned. Before certificate.
It should be part of the memo of appeal. It is after the certificate. It is not in the memo of appeal. File it. With
Lordship, if Lordship permit me, Lordship, because execution case has been fixed on 7, no? 7. Any date before that, Lordship. I will
all right. We will take it up. We can take it up on Tuesday or Thursday or Tuesday or Wednesday or
Tuesday, Lordship.
Tuesday.
Tuesday.
Heard, Mr. Gustafsson, Garnet, for the
I beg your pardon, Lordship.
Tuesday. So as to enable Mr. Gustafsson to file amended memo of appeal incorporating the suggested substantial question of law in the memo of appeal as provided under subsection 3 to section 100 of the
May I submit one thing, Lordship? I beg your pardon, Lordship. I want to notice judgment. If judgment is, Lordship,
Yeah, judgment is, yes, I will provide it.
Lordship, I'm sorry, Lordship. 30 is same, Lordship, at a 10-11. Lordship, regarding, Lordship, the deposit of amount involved is less than 1 lakh. 173, that is. Lordship.
Those two
Fixed.
cases perhaps date is fixed on 8.
Okay, as agreed
Yes.
by Lord and advocate to both the parties. 8.
Obliged, sir. Highly obliged.
You can, Mr. Goswami, you can take the judgment from the.
Lordship,
Sir,
Lordship.
after some time.
The service in this matter is completed and respondent perhaps
For hearing. Hearing.
admission.
Or it is admitted.
No, it is a appeal against the order passed by the appellate court whereby the case was remanded.
Admitted.
Not admitted, it will, if it is admitted, if it is kept for usual hearing, it will take time because only a simple order, small order was passed by the first appellate court whereby the first appeal was remanded back to the trial court, only allowing the defendant side to cross-examine the witnesses. The cross-examination was closed by the trial court, which was not challenged before any forum. They filed an appeal. In the appeal, when the case was fixed for passing judgment, they filed an application under Order 41 Rule 27 that the examination of the witness was closed by the learned trial court. He may be allowed to cross-examine. And on that basis, the learned first appellate court remanded back the matter, allowing the prayer made under in the petition file under Order 41 Rule 27 on the notion that it is a additional evidence, but no such evidence and no formalities were complied with as required under Section 41 Rule 20, Order 41 Rule 27. The case is solely remanded, giving an opportunity to the defendant side to cross-examination, which was earlier closed by the learned trial court, which was never put to challenge before any forum. This is the only small issue.
That's all right, but it is fixed under order column.
Yes. The Lordship may fix it for admission the next week.
No, it is already admitted. Order by order dated 4/8.
Yes, it is admitted. If it is put for hearing, then it may take some more time.
Said that.
Yes, then it.
Or Mr. Mr. for the appellant. So this is service, submit that service already completed and the matter may be for hearing. Accordingly, it is provided that the list the matter on. Okay. That part of other.
Much obliged.
LCR received matter interim order is there in their favor. Matter may come for hearing.
Admission. Matter may come up for admission, Mary.
Part Mr. and total product. Number 1 to 8.
Yes, ma'am.
Who is for respondent number 9?
The notices were served, but nobody appeared. In the last two orders, the same is recorded.
LCR was called for?
LCR was called for on the last.
It's submitted at the part that service completed. Then LCR has been received and matter is ready for admission. Accordingly, provided that it's submitted for admission hearing after 1 week.
The interim order may be.
Order after.
Deeply.
My lord, this is a case, my lord, where the police is sitting over the judgment of this honorable court for last 2 years.
On the last occasion also, they appeared and they took time for filing affidavit. There was a clear direction from this court to release the supari of the petitioner. The direction was made way back in 2023, 27/6/2023 at page number 37.
You are for the petitioner,
Yes, my lord.
but who is for the respondent?
My lord, on the last occasion, they appeared. Now they don't appear.
Who appeared on last week?
I see Mr. R. Gogoi. Your lordship will see the order dated 20th of March 2025.
It's a not river here.
Lordship, I am for the respondent number one, my lord, he contacted me, lord. Lordship, may give me some time, my lord. I have received some instructions, but it is not clear. The instructions given to me says that he was the OC of. Allegation is that allegation is against the OC of Sansari PS. But this particular person who has given me the instruction by name, he said that he was in not Guwahati PS. He's not the OC of that Sansari PS. I have some clarity is required. Malad, kindly give me some time.
But this is North Guwahati PS if I read the title correctly at page number 37. It is North Guwahati PS.
No,
My lord, may I kindly see page 36.
He has made him party, but the issue regarding that it was under the Sansari PS. I need some clarity, my lord. Kindly give me some time.
My lord, my only predicament is that, my lord, lot of time has elapsed, my lord. And
Lordship may keep it on next Friday, my lord. In the meantime, I'll get the clarification.
in that case, my lord, may fix a date, my lord.
Lordship. Kindly take it up on 8, my lord. I'll get the clarification in the meantime.
Mr. Visas, do you have Pukalatama here?
Yes, my lord, recently I have been engaged. My name is also reflected in the cause list.
Number one.
Yes.
One. Respondent number one.
Conducted some time of the dispensary. There is about on Friday, next Friday.
Madam. Lordship.
May please understand. In Lordship, item number 34, I am appearing as a applicant in IA number 2739 of 2023, Lordship. In this case, Lordship, I am seeking the leave of this honorable court to repair my sets, whereby one rice mill has been operating by me, Lordship, and which is my only means of livelihood. Lordship will find at page 11 annexure A, the photographs, whereby it is clear that the rice mill, the walls have been already damaged. So, Lordship, I am seeking only the leave of this honorable court to repair the rice mill for my livelihood, Lordship. And on last occasion, on 3/1/2024, Lordship, the appellant respondent hearing, they took 2 weeks time for filing objection, but till that objection has not been filed, Lordship. Though,
my lord, we are not fairly to submit. We are not getting the contact of the client, my lord, to file this objection. That's why some time is required, and moreover, my lord, because without objection to be required to file, my lord. That is the only. Although it is last time it is given, my lord, but the fact is that we are not getting the contact of the client. That is the problem.
it is of 3/1/2024, Lordship. Since then, it is 25, Lordship. July has over. Almost.
Okay, 1 week time.
1 week.
As last chance, Lordship.
A.Y. Chaudhary.
A.Y. Chaudhary. You are for the applicant?
Yes, I am for that. Applicants on provide.
For the opposite part. The opposite part then conducted some time to obtain instruction and file objection. This application there is
Obliged.
Obliged, Lordship.
How it is connected with
It is one IA Lordship. The IA might not be listed along with the second appeal. That's why Lordship, the IA maybe has been listed in the supplementary list, Lordship. IA 24 oh, IA 2465 2025. It is filed by the appellant for stay, I suppose, Lordship.
the second appeal?
Yes, Lordship. Stay is already granted. And
That's our
no, there is
Execution stayed on 18/1/2022.
and in the second appeal, Lordship, order may be passed. In the main second appeal, Lordship. As per Lordship, office note dated 15/9/2023 and 17/12/2023, Lordship. Office note may be perused, Lordship. Notice upon as per number 6, 11, 13, 14, 15, 16, 17, 20, 22, 24, 26, 27, 33, 34, 36, and 40. They have been received. Notice has been refused by respondent numbers 19, 21, 32, 37, 50. Order no, not Lordship. Office note, Lordship. Office note 17/12/2023.
No, thereafter several orders have been passed.
And Lordship, some of the respondents has also died, Lordship. But substitution has been filed.
Yes, ma'am.
One to five.
1 to 5. Some of the respondents
Have died.
respondent number
Respondent number, Lordship, 7, 8, 10, 12, 23, 28, 29, 31, and 35.
1 and 35 expired.
Expired. As per office note dated 17/12/2023.
The Lord has for the appellant. Some extent will obtain necessary and take necessary effort. Or implement of the legal effort. That's one. Here allowed for it, the matter after
14.
14.
Obliged, Lordship.
Yeah, please.
Yeah.
But I am for respondent number 1 and 3, my lord. Office note dated 25/07/25, my lord. It shows that the notice left unserved. Lord, it is the most probably the third time the notice was not served. Office note dated 25/07/2025. Upon respondent number 2.
You are for respondent number
1 and 3, my lord. 1 and 3.
1 and 3. None appears for the applicant on both over. Your good name, please.
SS Ahmed, my lord.
Ahmed, learned for the respondent number
1 and 3.
1 and 3 present. Office note dated 25/7/2025 indicates that respondent number 2 could not be traced out. Since the applicant remain absent. And on previous date also, that is on 30th/4/2025, the applicant remain absent. It is provided that this is the list of matter after 1 week. In the event of subsequent non-appearance of the applicant, the appropriate order shall follow.
Objection. Office note dated Your Lordship 23/7/25. Lordship, respondent, all have been served the notices, all the respondents. And so far as respondent 1 is concerned, Your Lordship, he expired. But however, 2 and 3 are the sons of respondent number 1. So it's being on record, Your Lordship. It will automatically substitute, Your Lordship. 2 and 3.
Not required.
Not required, Your Lordship, because 1 expired, no doubt, but 2 and 3 are the son of 1, respondent number 1.
Okay.
And so far as 4 is concerned, 4 expired, Your Lordship. 4 expired.
Yeah.
Yes, in that case, Your Lordship, substitution may be required. But thing is that, Your Lordship, all the 8, Your Lordship, is not found. Not found, but the addresses are same, Your Lordship. All the respondents belong to the same address. And 8 is shown to have not found.
You take cases there.
With regard to 8, Your Lordship. Okay then. Okay then, Your Lordship, I will take.
Heard Mr. P. Sharma, learned for the appellant. Office note dated 23rd/7/25 indicates that respondent number 1 suffered demise.
Yes.
Respondent number 1 and 4 suffered demise. Then respondent number 8 would not be traced out. Would not be traced out. No, address is not found. And in respect of rest of the respondent, service complete. So Purna submits that to respondent number 1 suffered demise. Yeah, respondent number 2 and 3 are his son. And they will represent the
Yes.
the respondent number 1. And in respect of respondent number 4, he will take necessary instruction and will take necessary steps to complete the legal heirs of the respondent number 4. And in respect of respondent number 8, he will take best step. By registered both with PD and also by the person.
And
Leave the matter after. Sorry.
And one more prayer, Your Lordship. In view of the order dated, Your Lordship, 9/4/25, Your Lordship, already a substantial question of law has been framed. So in this regard, may I pray, Your Lordship, that LCR record with regard to title suit case number 343 of 2014 may be called for.
Record was not called for, yeah.
No, Your Lordship. Just only notices were issued and substantial question was formed. So report.
The appellant submits that no substantial question of law was
Framed,
framed by
yes.
the dated 9/4/2025. The record has not yet been called for. And as such, it submits that the record from the learned courts below may be called for. Recording date is provided that this is called for the record of the learned courts below.
Title suit case number, Your Lordship, may be mentioned, 343 of the 2014.
Or rest we will take care of.
Because, Your Lordship, the thing is that title appeal, Your Lordship, the title appeal has not been, Your Lordship, heard due to, Your Lordship, the condonation of delay that was being rejected. So in view of that, Your Lordship, the title suit case number may be called for, Your Lordship, because only title suit is remaining, Your Lordship, because title appeal have not been heard.
That's all right. Both the appeal will, both the record will be called for.
No, Your title appeal was not being heard, Your Lordship, because while filing title appeal, Your Lordship, condonation petition was filed, but condonation petition was rejected, Your Lordship. So
That order has to be called for, that record.
Your Lordship, title suit case number, Your Lordship, the LCR of title suit, Your Lordship. Because against, Your Lordship, that rejection of my condonation petition, Your Lordship, this RSA has been filed.
No, rest will definitely call for the record.
Yes. Your Lordship may kindly refer, mention the case number, Your Lordship.
No.
Lordship, kindly timing, Lordship, possible for timing. My senior is attending on another court case.
My lord, in this time, in this point of
Yes.
time, no timing, my lord.
Kindly, Lordship.
Then, my lord,
Who is your senior?
Then,
He's in
my lord,
court number 24, Lordship. His item
then, my
number is
lord,
running, Lordship.
that may be fixed, my lord.
Kindly for 5 or 10 minutes.
So, Sohan, wait for something.
There is a delay of 38 days in preferring this testamentary appeal.
One respondent, no?
Yes, sole respondent.
Yes, my lord, I am appearing on behalf of sole. We'll file one objection, my lord. in this action, my lord.
34 days.
File objection.
38 days delay, my lord.
Yeah. You see the explanation, they have moved forward.
Let it be put forward in writing, my lord, a short date, my lord. It won't take much time, my lord.
Will delay the proceeding, it only.
No, but a short date can be 10 days time.
34 days, this honorable court is satisfied with the explanation given in the paragraph.
Yes, I've seen it, my lord. 10 days time may be granted. We'll file.
Not 10 days, 1 week.
One. We'll do.
Applicants, Mr. Your good name, please.
Yes, my name is H.
Yes, already, for the opposite party. So, Sodri submits that, file that is right. However, 1 week time is granted. This is the matter on.
Fine. All right.
Much of it. Much of it.
All right.
May I please your lordship? There is a direction to file affidavit. Oh, sorry, there is steps to the service and the service has been completed. We have filed an affidavit.
Art means?
As per on behalf of BJ Mukherjee.
On behalf of Mr.
BJ Mukherjee. May I please your lordship? There is an interim order on IACV.
Then also art is the provider
One and two.
1 and 2. The learned concept for the excellence submits that. Service upon respondent number 3 was affected by the same and affidavit that effect has filed. And it appears that service upon the respondent number 3 completed. Record will be required or not?
Record, my lord. In fact, your lordship would need an earlier order in this regard.
So, this matter has not yet been
Earlier,
admitted, sir.
my lord, the question in earlier order dated 26/5, court observed that as the question involved in the instant appeal is a short question of law, record would not be necessary. Record are not called for.
Then we'll list it for admission hearing.
Already admitted,
Where?
already. Your lordship will see.
Where?
Earlier order 26/5/25. Taking into account above, the instant appeal is admitted.
Which part?
My lord, earlier order dated 26/5/25
Paragraph
and
number.
paragraph 3.
Okay. Let me get. Let's list the matter for hearing. After
In usual course, it will come.
in usual court.
My lord, interim order.
Interim order itself.
Much obliged. Yes, sir. May it please your lordship, this is a review petition. Recently, lordship passed a judgment, lordship. In that lordship, the trial court had given us a right to recover the amount from the owner. That was not mentioned in lordship's judgment. That's why we have, I think notice will go before.
Trial court has given order for recovery.
Yes, lordship.
Where?
In the judgment, it was mentioned that. We have not annexed here. We have prayed for calling the record of MSc appeal as well as.
It's a review petition card for reviewing the order judgment and ever dated
19/6/2025.
It's under order 47. Order 47 to 1A, they do it section 114 and 117. Order dated 95. It is 14 MSc appeal number 08. Where's the petition? And the judgment dated 95. Returnable for it.
Yes.
Certificate by registered for alien. Now we come to call for the record of MSc appeal number
MSc appeal number 208 of
2006
and MSc case number 931 of 2013.
and MSc 931 of 2013.
13.
41.
Hello. 41 lordship listed for the first time. There is a delay, lordship.
Delay of?
Delay of 300 days, lordship.
Notice.
Yes, lordship, notice will go. And 42 also, lordship, but delay is less. The delay has to be.
Notice.
Delay is different. Hello, obliged, lordship.
43.
May I please, your lordship, it is listed for first time, my lord. There is delay of 6 days, my lord.
Okay, then notice.
44, 46, 35 days delay, my lord.
Okay. Okay.
46.
May it please your lordship, it has come up for a first time delay of 34 days. Oblige it.
53.
46. 46. Excellent, 46. 46.
How many days?
No, my lord, notice is not sub on respondent number 2 and 3, my lord. We have again take first step with correct address, my lord. 46.
Okay, we'll talk for.
Yes, oblige me.
Yes, Mr. Roy.
My lord, initially there was 53, 50. Yeah.
Item number 20.
Item number 53, my lord.
My lord, initially there were 14 days delay, my lord, but we went to the wrong forum, my lord. Then we have asked to take dusty service, my lord. On 22/7/25 we taken dusty service, my lord. And practically, my lord, we filed on the same day after withdrawing that petition, my lord. On the same day we filed the revision application, my lord. So your lordship may see first, my lord, the page 12 order, my lord, that 14 days has been condoned. Lordship may say page 11 starts, my lord. Page 12 is the relevant portion, my lord. That was condoned, my lord, 14 days delay. And thereafter it was, because it was filed in the wrong forum, my lord. Page number, my lord, 12.
Yeah.
So this is an application filed under section 5 of Limitation Act so and so. Read with order 3A Civil Procedure Code 1908 for condoning the delay of 14 days in preferring the accompanying appeal. The land council on behalf of the respondents submitted that the instant appeal is not maintainable so and so. So there was a 14 days delay. So we have withdrawn the on the same day, my lord, we filed this appeal. So there is delay of, my lord, 50 days, my lord. So
Delay of
50 days, my lord.
50.
50. Actually, initially 14 days, my lord, but we in the wrong forum. There was an additional delay of 36 days, my lord. So on the same day, after withdrawing, on the same day we filed this application, my lord. So only my anxiety is that, my lord, the matter is fixed on 7th, my lord. So lordship may hear it any day, my lord, before that date. After condoning the delay, my lord. On merit, lordship may decide the issue, by lord.
You have to be registered.
Yes.
Or
Yes. Yes. It has to be registered. But the lordship has to condone the delay, matter. We have served the notice to the other side also.
My lord, notice has been duly received by the respondents and instruction has been received to appear. My lord, the problem occurred, my lord. Earlier RSA was filed, we have appeared, filed Wakalatnama, we have also filed the affidavit in objection. Later on, my lord, the respondent number 4, who is the authorized representative of all the respondents, he left to Mumbai for the treatment of his wife who is suffering from cancer, my lord. So subsequently, we have received the notice, but Wakalatnama has been sent by by courier, my lord, and he has returned the Wakalatnama by signing, but still I have not received, so I could not file the Wakalatnama today, my lord. So, however, in RSA, I have filed, my lord, that was against the same order. I will file subsequently, my lord, and I have no objection as to the delay, my lord.
Or the
All the respondents.
This application under section 5 of the Act is deferred by the of 3 days. Sorry. Connected to civil petition against the judgment that it is right caused by the learned court civil the seniority Sagat title 5 of what is the why it could not be filed in time? What is the parsing the matter in wrong forum?
Wrong forum. There's a 36 delays for that matter.
Entire delay.
Entire delay, the 36 days delay because of that. And 14 days delay is already condoned, my lord. I've read the order, my lord. So initially 14 days, my lord, but wrong forum 36 days, my lord. So total 50 days.
14 days already condoned.
Condoned, as lordship I've seen page 12 order, my lord. Page 12. Third line, my lord. 14 days delay.
Mr. Roy learned concept for the applicant submit stand. Out of 50 days, 14 days delay has already been condoned by this court by order dated 23rd 6 2025 in IA Civil number 1887 of 2025. And the rest of the delay had taken place due to pursuing the matter in a wrong forum. Then as such, the delay may be condoned. The civil revision petition may be admitted for hearing. Its nature submits that conflict like that of the delay. Taking the submission of granted computer concept for both the parties and also the concept court and the explanation so put forward it by the concept for the applicant. This court is of the view that the delay is sufficiently explained and according to the things conduct. In terms of this IA stance, disposal and view of the order passed in IA, the registry will register the CRP and take the same for the court as soon as practicable.
On 7th is the next date, my lord, execution.
Plaintiff is not available, so execution will not be executed. The writ will be not executed in absence of the plaintiff. So any date may be, no, he will be not coming right now.
So that will be recorded. That
That may be recorded.
may be recorded.
Because if
Otherwise, 7th, my lord, there is execution date is there.
Then-
The plaintiff is not available, so they cannot execute.
Where I will record this submission.
I'm sorry, my lord. Lordship, you may fix it
No,
on.
we'll fix it sorted.
Because my lord, I have
It may be
to
fixed on 7th.
prepare the objection as well as affidavit in objection, then I have to send it to Mumbai, then he will sign and send it back. So my lord, so that will not. Because he is engaged in hospital, my lord.
No, that's all right. Also, let us admit the
Appeal.
petition. Thereafter, we'll take.
The stay is there, my lord. IA for stay is also there, my lord.
Okay, we'll consider it on that day. So, 5th of August.
5th of August, my lord. Oh, 4th, my lord. I'll be traveling, my lord.
Okay.
4th of, obliged, my lord.
One second.
Confusing, my lord, because in the I filed the appeal, my lord. That time I was there, my lord. Now he has filed the application, my lord, regarding all. Yes. Huh? My lord, he has alleged that during the pendency of this second appeal, this he has alleged and filed a ukalatnam, this FIR. Lordship, kindly have a look. His IA.
No, Mr. Secretary, to
Lord.
take this application,
And
IA civil number 1640/2024 has been.
filed by him, my lord.
My lord,
And that too, my lord, without my information, no notice was served to me prior to filing this petition, my lord. And when I have come to the notice, then only I have come to know that this case is there. And on that particular day, interestingly, my lord, in the notice itself, my signature was shown fraudulent. I did not sign, but my signature was shown. And this is what happening, my lord, in the proceeding. And my lord, surprising enough, my lord, we are doing this type of practice here for, and I'm surprising, even after running of 35 years practice in this court, I didn't see like this, my lord. Anyway, my lord, here, they have also filed this application by enclosing one FIR, my lord. Lordship, kindly have a look.
Oh, so do I hear the matter today?
No, here, my lord, only they have stated this FIR. Lordship.
My lord, I have filed my lord by my lord.
My lord, this.
My lord started arguing on my petition. Let me, my lord, first.
No. Only here, my lord, here, this, when they have come before this honorable court, regarding this, I only I'm arguing, my lord, on this matter, my lord.
IA has been filed without having any FIR registration number, without GDA entry number, and stated that pendency of this case, I have constructed the house.
Mr. Secretary,
Lordship,
it is already 4:35.
that is the problem.
Yes, let us fix under it.
Sorted, my lord, because already I have been suffered, my lord, in this case, my lord.
So one learned counsel for the applicant and Mr. Secretary for the respondent opposite party. This
Tuesday,
I.
IA.
Further consideration.